Kim, would you mind doing the housekeeping?
I think she asked me to do
okay.
it.
Oh, thank you, Erica.
No problem. Welcome, commission members, liaisons, and members of the public. Thank you for joining us. We'll be beginning shortly. We're using Zoom with the goal to foster a more inclusive environment in the meeting. If you'd like to comment during the meeting, please type "I have a comment" or "I have a question" in the chat, and a message will be sent to the host. Alternatively, you can also use the raise hand feature. In efforts of transparency for all those joining this public meeting, whether by phone or Zoom, we request that you refrain from having side conversations on chat about the content of the meeting. Again, the chat feature is utilized simply as a tool for you to virtually indicate that you would like to speak in order to help the chair facilitate the discussion. Please note, all Legal Services Trust Fund Commission and committee meetings are recorded and posted to the State Bar website. Also, a friendly reminder that this is a video conference, and please be aware of your surroundings.
Okay, very good. Thank you. So we're a couple of minutes after the hour. The folks are starting to just drop in. I know that we just came out of the Eligibility and Budget Review Committee meeting. So just to give people a chance to take a moment between the two meetings would be probably good.
I'm counting, and I don't believe we have quorum yet.
Yes, okay, thank you. We'll hold on.
Oh, Kim, I see Judge Seligman is in the, would you mind promoting him? Thank you.
I am here.
Great. Hi, Judge Seligman. We're still gathering. We haven't taken roll yet.
Welcome.
Hi, Barisha.
Hello.
Oh, Kim Zahira is also in the waiting room. Would you mind promoting her?
Juan, are you able to see who's raising their hand?
I think I have that visibility today. It's odd because sometimes I don't, but I think I do today because I saw at eligibility, I was able to see. Yes, like I see Louise raising her hand right now.
I'm just testing it for you.
Thank you. And Kim, Justice Murray is also in the waiting room in the attendee.
How are we
Do
doing?
we have quorum yet? I'm seeing a lot of
Yeah,
squares.
Yes, I believe we do now. If you'd like me to do roll call vote.
Yes, please go ahead.
Great. Welcome everyone to today's Legal Services Trust meeting. My name is Duan Ying. I'm the staff coordinator for this meeting, and I will do roll call. Aglagi?
Here.
Iskin?
Yes.
Thank you. Rhinus, Savage, Al-Saraf,
Yes.
Ball,
Here.
Bartleson, Whitemaster,
Here,
Bennett, Pamela Bennett, Blakemore,
Here.
Bashelli, Will Bashelli, Connolly,
Here.
DeBose,
Present.
Delfino, Rebecca Delfino, Friedman, Corey Friedman, Mann,
Here.
Meeker,
Here.
Plantold,
Here.
Schreiber,
Here.
Vanarelli.
Here.
We have quorum. Let me do the advisors. Judge Haskell,
Here.
Justice Murray,
Here.
Judge Seligman,
Here.
and I'll do our liaisons. Selena Copeland,
She is joining by phone, Duan.
okay, great. Bonnie Huff,
Here, thank you.
Ganong, Christine Ganong,
And Duan, Selena is here too. I just couldn't figure out how to unmute myself.
oh, okay, thank you,
here.
Selena. Mark Tony,
Present.
and then State Bar staff, Elizabeth Home,
Here.
Carol,
Here.
McConkey. Chris, are you there?
Me? This Chris?
Chris McConkey is being promoted to panelist right now, so
Okay, great.
yeah.
Danielle McCray,
Here.
Donna Hershowitz,
Here.
and Brady Dewar. Great, I'll hand it back over to you, Bonneche, for public comments.
Okay, great. Just before we go into public comments, I wanted to just give a little update. We've been working really hard on the issue of expungements on our side. And there seems to be a recommendation that we're getting closer to and we're approaching to providing. And I just wanted to give that framework out before we move into public comments. Just potentially it would help. The approach is to define the civil legal services that are related to specifically expungements, record sealing and clearance proceedings, and infractions. And with that, I will move to public comments. And let's please reserve the time. We have a very, very heavy agenda to about 2 to 3 minutes per person, please. No more than that. And Duan, if you can help me as you can start to see people wanting to come in to make any comments, should there be any comments.
Sure. If you're a member of the public who would like to introduce themselves and or make public comments, can you please raise your hand and we will unmute you. I don't see any hands raised. Let me see the message. I don't see any public comments. There are some attendees, but nobody has their hand raised.
Okay, very good. Then let's move to the third item, approval of the meeting summary and action items from the June 25th, 2021 meeting. Do I have a motion?
So moved.
Thank you. And a second?
Sorry, was that Eric? Sorry.
That was
Yeah.
Eric. Yes.
Second, Bob Plantel, second.
Very good. Thank you. Shall we go to a roll call vote? Dawn?
Sure. Aglagi,
Yes.
Iskin,
Yes.
Al-Saraf,
Abstain.
Ball,
Yes.
Bartleson, Whitemaster,
yes,
Bennett, Blakemore, Blakemore? Catherine, are you still there?
Yes, I'm here. I just was challenged by unmuting.
Okay.
But yes, I'm approving.
Boschelli?
Yes.
Okay, great, you're here too, thank you. Connolly,
Abstain.
DeBose,
Yes.
Delfino? Friedman? Mann,
Yes.
Meeker,
Yes.
Plantold,
Yes.
Rhinus, Savage, Schreiber,
Yes.
Vanarelli,
Yes.
motion passes.
Very good, thank you. All right, let's move on to the fourth agenda item, and starting with 4A, our co-chair reports. Eric and I this will be our official last meeting co-chairing this fine body and turning the reins over, if you will, or passing the baton to two very qualified, capable colleagues of ours. I know that Eric and I were talking about how we were going to do this last meeting and what would be an appropriate way. And we thought that as our send-off, it would be appropriate to co-chair it, like actually co-chair it. So I will chair the first half of the meeting, if you will allow, and then Eric will, though his name on the Zoom here says Jonathan, but it really is Eric, will co-chair the second half. But I wanted to also give a couple of minutes for Eric to make any comments here, and then for us to introduce the new co-chairs, who both are not here today, I think. I don't know if Kim Savage is here either. Yeah, both are not here. And then also introduce the new co-vice chairs. Eric, if you have any words.
Yeah, thank you. My formal name is Jonathan Eric Iskin. I go by my middle name, Eric, so I know that confuses everybody, and I apologize for that. Thank you, Bonafide. It's been a pleasure to have co-chaired the commission this year and worked with all of you. And I do look forward to, and I'm very happy to say that we've got a very, very talented and wonderful crew taking over. And I will also say, just to be sure that we all know, that the process for choosing the executive committee was an open one and a transparent one. Duan did send out a note, I believe, to all the commissioners asking for anyone who was interested to step forward. And so that was a process that we followed, and the 4 people who were selected did step forward. So anyway, look forward to the great transition. And again, thank you all for teaching me a lot this year. I've enjoyed it.
I echo definitely Eric's sentiments. It's been an honor to serve, especially during the complexities that we've all been writing the last year, 2, 3 years. And it's been I think it's, for me, one of my greatest joys to be able to chair, and not only a chair, but to be a member of this commission. So the new co-chairs will be Kim Savage and Rich Rines, and who are senior commission members with a lot of experience in their own right, as well as serving on this commission. So this commission is in great hands going forward. And the new co-chairs are Christina Vanarelli and Christian Schreiber. And again, 2 senior members of this commission, and really looking forward to your leadership and taking us through the next stages of things here. And with that, let's move to the State Bar Report and the Board of Trustees, if you would please, Mark and Christine.
Thank you very much. I don't have anything to report new at the moment. So thank you.
Thank you. All right. And Christine is with us, or?
I don't believe she's on right now.
Okay, very good. Then moving on to C. And I believe this staff update on the grant administration and legislative activities will be driven by Donna. And Donna, thank you for being here, and Duan.
And I'll do the first half of it. I'll provide some update about the legal aid funding, and then I'll turn it over to Donna to do an update on SB 211. So the biggest update that I know I've been sending out a flurry of emails since our last commission meeting, but the governor signed the budget, and it does in fact provide for a substantial increase in legal aid funding. And I know all the committees have partnership and HP committee have met, and they will bring forth a recommendation to you for a distribution plan. But I just wanted to go over again, high level, what the state budget provides for us. So the Equal Access Fund base, previous to this increase, was $20 million. The new state budget for 2021 provides an additional $15 million on top of that $20 million base. The Legal Services Trust Fund Commission will be administering 45 of that $50 million increase. The other $5 million will be administered by the California Access to Justice Commission, and they will be providing innovation grants. We also want to remind you that as part of this, the annual state budget, there's up to $5.5 million roughly that's appropriated for filing fee revenue. And this is to follow up to the email that I sent yesterday. The filing fee revenues from year to year have been volatile, and they've been more volatile in the last few years. Usually the Judicial Council works in conjunction with State Bar staff to kind of come up with a projection for the following year for filing fees. Originally, Bonnie and I were thinking in the realm of $3 or $4 million, but there's actually pending legislation in terms of fee waivers that raises, the proposal is to raise the income, income eligibility for people that qualify for fee waivers. So it's because of that pending legislation, we've decided to be conservative in the filing fee projection. So we are projecting for next year about $850,000. So if you include the filing fee revenue in addition to the increase of funding next year, and you subtract out the administrative expensive, the Legal Services Trust Fund Commission is going to be able to distribute around $57 million for Equal Access Fund grants, and then another $6.4 million for partnership grants. So this is, again, a substantial increase, and we are just so happy, the staff, to be working with the commission and Judicial Council to be administering these funds. And you'll hear a lot more about the distribution plan in the business section of the commission meeting. In addition to that, the state budget also provides $40 million from the American Rescue Plan for homelessness prevention. The way the state budget works is that it's approved 1 year at a time, but we have been assured that $40 million, there will be an additional increase the following year of $20 million, and then the following year after that, another $20 million. So $80 million total for homelessness prevention. And then just two more quick updates on legislative activities. SB 498, this is the legislation that proposes to increase the income threshold from 125% to 200%. It's still making its way through the legislature, and we've been informed that we don't anticipate any opposition, and we expect it to be passed. So we hope to provide you an update even before the next commission meeting that legislation is passed. AB 1487, this is the legislation that establishes an ongoing homelessness prevention funds. It is still live. We don't know the likelihood of whether it's going to be passed, or if it's going to be passed, whether it will be funded, but it is still live because we are still fielding questions around AB 1487. And if there's movement around that, again, we'll email out an update if it's before the next commission meeting. So that's all of my legislative updates. So I'll turn it over to Donna now to talk about SB 211.
Great, thank you, Juan. I apologize, I don't have much of a voice, so I'm going to do my best. SB 211 includes language codifying the Trust Fund Commission. Up until today, the Trust Fund Commission exists in rule only, and so this language creates the trust fund by statute, the Trust Fund Commission by statute, and sets forth its authority and independence, and how it operates within the state bar. We are continuing to work with the Assembly and Senate Judiciary committees on some amendments to this language. But I think it is in part an important recognition of all of the additional funding that Dwan just talked about and the important role of the commission in administering that funding for the legal services programs and the Californians who need it. There are, I expect there will be amendments to the language over the next couple of weeks, but we are continuing to have conversations with legislative staff about that. We will keep you updated as the amendments are discussed. I'm happy to take any questions.
Thank you, Donna. Any questions, thoughts on Dwan or Donna's presentation? Very good. Thank you. Let's go ahead and move on to business. I think this agenda item discussing an approval of the recommendations for 2022 partnership grants funding is for Elizabeth and Christina.
Okay, I'll start off. The Partnership Grants Committee has been hard at work reviewing the 36 proposals that were submitted. In total, the requested amount was 3.094 million. We had about 2.5 million to allocate. So we had to go through and score them and make our recommendations based on that. Attachment C to the memo that's in your materials has the recommendations that we are making to the commission today. Does anybody have any questions about any of those or comments? All right. Well, if the commission approves, these will be presented for the Judicial Council's approval at its September 30th to October 1st meeting. There's a resolution recommended on page 4 of the memorandum. Oh, good. And this is what the committee is recommending that the commission adopt today. Are there any questions? Oh, there you go. Okay, hearing none. Is there a motion to approve this resolution?
So moved.
Bob, thanks.
I will
second.
Jeff?
Sure.
Thank you. All right.
All right, let's go to a roll call vote.
Yes.
Sorry, my sheet was, okay. Aglagi,
Yes.
Iskin,
Yes.
Al-Saraf,
Yes.
Ball,
Yes.
Bartleson, Whitemaster,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
Washelli,
Yes.
Connolly,
Yes.
DeBose,
Yes.
Delfino, Friedman,
Yes.
Mann,
Yes.
Meeker,
Yes.
Plantold,
Yes.
Rhinus, Savage, Shriver,
Yes.
Vanarelli.
Yes.
Motion passes.
Very good. Thank you. Christina, there's more?
There's more. This is the exciting part. On July 12th, Governor Newsom signed the Budget Act into law, as Dewan said, and that act appropriated a lot more money in equal access funds. And that resulted in the Partnership Grant Fund having an additional 3.8 million to allocate. That's compared to the 2.5 million we just talked about. So it's more than double. So the Partnership Grants Committee met and had to figure out how are we going to get this money out. And what we're recommending is what we are calling Partnership Grant 2.0. We're recommending that this extra pool of money be administered as a separate grant and require a new request for proposal. We're recommending that the applicants be subject to the same threshold eligibility requirements required for all partnership grantees, and that includes it's a partnership with the court, for example, that it's an existing program that's already receiving IOLTA funding, and there are a couple of other threshold qualifications that we recommend remain the same. Applicants would also be subject to mid-year reporting requirements pursuant to the Budget Act language. So we're recommending two options that programs can choose, and they can actually do both if they wanted to. Some of our projects have multiple partnership grant projects, so they can do both of these options if they want to. Option number one is, as I mentioned earlier in the prior resolution, we didn't have enough money to allocate to fully fund all of the applications, to give everybody all of the money that they were asking for. So option number one would give those programs that didn't get all of the money they're asking for the option to apply for the difference. They would also have the opportunity to improve their applications, and we would provide them with their rubric scoring to see where maybe their applications could have some improvement, because we're going to score again. This would be a shortened grant period from April 1st, 2022 through December 31st, 2022. So that would be option one. And then we're recommending that programs be allowed to also submit new applications. And our intent for that is to encourage them to develop unique and larger scope projects, or to propose a substantial expansion to an existing project. This option would have a 21-month grant period, so it'd be from April 1st, 2022 through December 31st, 2023. And we're recommending that for this option, the minimum funding request be $75,000 and the maximum be $300,000. On the traditional regular partnership grants, there was no minimum, and we typically cap the maximum at $120,000. But we're looking for large projects, innovative projects to serve a lot of people. So that's why we're making these recommendations, because we have the money to do that and to get it out and to do great things. We're also recommending no carryovers be permitted, and that we utilize the same scoring rubric as we have for 2022 that we've been using. Also, you might want to know that if we're not able to get all of this money out in terms of partnership grants, we don't lose it. It just goes back to the Equal Access Fund and goes out that way. So that's good. And staff and the committee plans for targeted outreach. We really want to get this money out to quality programs to serve as many people as we can. We have a proposed timeline, which is on page 4 of the memo. And also on that page is the recommended resolution. So does anybody have any questions about any of that?
Just one question, Christine. First of all, thank you to you and the committee. Great work here. Question I have is, should the resolution include the language requiring the Judicial Council to approve? Similar to what we just approved.
I don't think that was in the other resolution. It just, they just have to, right?
Elizabeth, do you want to jump in there?
Yeah. I was going to say the resolution from the Trust Fund Commission is to approve this recommendation, and then that resolution goes to Judicial Council, and then they will approve it separately. So I don't think we need to name the Judicial Council in our resolution.
Good.
Right. Do we have a, Christina, is there a language for, and Elizabeth, language
Yes,
for?
I'm pulling up now.
Would one of you like to read the language?
Sure. Should the Legal Services Trust Fund Commission concur with the committee's proposal? The committee recommends passing the following resolution. Resolved that the Legal Services Trust Fund Commission approves the proposed timeline and distribution plan for Partnership Grants 2.0.
Do I have a motion?
That works for me. I'll make the motion.
Okay, and a second?
Second.
Was that Christian?
Yes.
Okay.
First, okay, great. I'll do
All
roll
right.
call vote.
Please.
Aglagi,
Yes.
Iskin,
Yes.
Al-Saraf,
Yes.
Ball,
Yes.
Bartleson, Fight Master,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
Bashelli,
Yes.
Connolly?
Yes.
DeBose,
Yes.
Delfino, Friedman,
Yes.
Mann,
Yes.
Meeker,
Yes.
Plantold,
Yes.
Rhinus, Savage, Schreiber,
Yeah.
Venarelli,
Yes.
motion passes.
Very good. Thank you.
Thank you.
Thank you for all that great work. Okay, moving to item B, please, for the discussion approval of recommendations regarding the proposed timeline and distribution plan for additional partnership grants. Again, is that, that's what we just did? Okay, let's move to C then. Discuss and approve recommendation for the eligible and ineligible applicants. The two Ericas, please.
Yes, hi. I will turn this over to Erica Carroll because she can get into the details. But basically, at a high level, eligibility and budget committee has met several times over the summer. We now have finalized our list of organizations that we believe should be found eligible for funding. And then there's about 3 that we recommend should be found ineligible. And so I'll turn it over to Erica Carroll to give you a little bit more of the detailed information since she's much better presenting that than me. And I'm happy to answer any questions as we go.
Yeah, thank you. So we initially had 108 applicants this year. 100 were returning and 8 were new applicants. 2 organizations withdrew, so we currently have 6 new applicants pending. 84 of them would be qualified legal services projects providing direct services, and 22 would be support centers. Of the 6 new applicants, 3 presented with no eligibility questions or concerns regarding their application, but 3 of them did warrant some further discussion and analysis. And so the Eligibility and Budget Review Committee met with those 3 organizations to discuss their application. And that was Catholic Charities, Diocese of San Diego, Community Lawyers Incorporated, and East Bay Family Defenders. Very broadly, sort of the questions related to these organizations. With Catholic Charities, it was a primary purpose determination, whether they had a primary purpose of providing free legal services to indigent persons. East Bay Family Defenders, the main question with their application was both primary purpose, but as well as the actual calculation of their qualified expenditures. The working group didn't believe that their income screening process was comprehensive enough to have an accurate reflection of their expenditures that were devoted to eligible clients. And then Community Lawyers Incorporated, the question that was, or the main questions that were identified for that organization were their oversight and quality controls. So they are a very small organization, and they have an executive director who also functions as their staff attorney. They do engage a lot of pro bono support, so a lot of their cases are handled by pro bono, but that was sort of the nature of the discussion, was their oversight and their practices. So those 3 organizations, 2 of them, Catholic Charities and East Bay Family Defenders, were recommended ineligible, and Community Lawyers Inc. is recommended as eligible this year. Some other things that the committee was looking at during the eligibility process was pro bono allocations. So organizations that, and sorry, I'm kind of getting into the next agenda item a little bit, but organizations that provide as their principal means of legal services pro bono, the services of pro bono attorneys, can apply for a pro bono allocation, which is additional funding in the counties in which they operate, in order to provide those services. And they can also use a higher income threshold. And for the pro bono allocation, we received 19 applications this year. 6 of those were presumptively eligible because they were able to show that their volunteer time was in excess of their staff time. but 13 of them required review by the committee because they had to provide a narrative explanation as to how they provide services and why they would consider that their principal means through pro bono. So after discussion and reviewing the explanations from those organizations, the committee wound up recommending 11 of those 13 as eligible for the pro bono allocation and 2 as ineligible. One of those, Inland Empire Latino Lawyers Association, was due to the fact that they didn't meet the threshold test, which is that they need to recruit either 30 attorneys, 5% of their county's attorneys, or receive at least 1,000 hours in donated attorney time. So that made them ineligible. And then Learning Rights Law Center was a first-time applicant for the pro bono allocation, and the committee didn't feel that they had quite fully explained sort of the nature of their services or the way that this is their primary means of service delivery. So they were recommended as ineligible for the allocation, but eligible and just as a qualified legal services project generally. They also went through the support center deeming process. So every 3 years for support centers that were not in existence prior to December 31st, 1980, they have to go through a deeming process where qualified legal services projects they find the services provided by these support centers as necessary or of special need to them. So they need a majority vote of the QLSPs, and all 4 organizations that were being deemed this year, they met that threshold or exceeded it actually. And so that was for California Advocates for Nursing Home Reform, California Women's Law Center, Public Interest Law Project, and WorkSafe. So, so ultimately, the 2 recommendations that came out of the committee to this that the commission needs to look at are ultimate eligibility for 2022 funding for all of the applicants for whether QLSPs or support centers, and then also the recommendation regarding pro bono applicants. So
Erica, there's a question from Judge Sullivan in the chat, and Pamela Bennett also has her hand raised. And I can read you Judge Sullivan's question.
I can say it. Who are the 3 groups as far as the new applicants? Those new applicants are IEP Collaborative, Loyola Marymount University, and Open Door Legal. So IEP Collaborative provides services, I believe mostly in Northern California and the Bay Area and perhaps Sacramento. Loyola Marymount works in Southern California, primarily in Los Angeles, but they do provide some services in the surrounding Southern California counties. And Open Door Legal has a variety of services, I believe housing, consumer law, family law, and a couple others, and they operate exclusively in San Francisco. And so they're all qualified legal services project applicants.
And Pamela, you have a question?
No, my machine is going kind of sideways, so I apologize for that. No comment right now.
No worries. Okay. Erica, does that conclude your presentation?
Yes, just one more thing. So as I mentioned, there are 2 organizations that are new applicants that are recommended as ineligible, being Catholic Charities and East Bay Family Defenders. Also, Family Legal Assistance at Jock Children's is being recommended as ineligible. They are a current grantee. However, they did not submit a reviewed financial statement with their application. And then upon further follow-up with the organization about some other missing documentation, they indicated that they weren't going to proceed with the application process. So we haven't received any updated information from them, but they're included on the list because they haven't officially withdrawn their application either. So in the materials that were provided to the commission, there are 103 organizations recommended as eligible, and then the 3 that I mentioned recommended as ineligible in 2022.
Great, thank you. Any other questions or comments from the commission? Okay, hearing none, shall we move forward?
Erica, do you want to put up the motion?
Do you want to put up the language, Erica?
I think the way it was in the memo, it was, it may need to be broken out. It was combined with the Bono allocation. So. So again, separately, I can take this top part out.
Actually, I just want to make sure I have a clarification on the East Bay Family Defenders.
Sure.
As I read it, it was they were only able to survey 20% based on the eligibility requirements of being indigent. But that was still, if they served 8,000 people, that's still about 1,600 people. Is that correct?
I don't know off the top of my head. I can run the number, but the main issue with their application was if you accepted sort of, they essentially were extrapolating. So they said we were able to get income information from a small percentage of our clients. And so we want to assume that's representative and say that that's the case for all the rest that we didn't screen. Whereas most organizations are able to screen close to 100% of the clients that come through their door. So that is a major distinction between them and other grantees. And so it was based on an estimate, not an actual known amount that their qualified expenditures were estimated between 64 and 68%. But really the main issue was that we couldn't be certain that what they were saying, the actual dollar amount of their qualified expenditures was accurate because they had to estimate, like it's a very large estimate. And that impacts not only their grant award, but all the other grantees that are applying in the same. So it's not that they didn't serve any indigent persons or, that we don't agree that what information they were able to obtain was accurate, but that it's not representative. There's low confidence that you could kind of extrapolate that to the rest of their client population.
Okay, I think I understand what you're saying, that this sampling we don't believe is accurate. Though
it's not that it's inaccurate, it's that it's not sufficient to show to extrapolate in the way that they would like to extrapolate. So if they had, for example, screened a larger percentage over more time, it might be easier for us to take it as the extrapolation. But it's not that we're saying that they're inaccurate. It's just what the amount that they actually tested or screened. We are concerned about whether they can then apply that to the other 80% of people. That was the concern that we had. Erica, correct me if I'm misspeaking, but I think that was the issue.
Yeah.
The process is inadequate for statistical reliability. The process is inadequate for statistical reliability.
Does that address what you're asking about, Will?
Yeah, I think that was the clarification, that was the interpretation. I mean, it's been sorry about that. It's been a while since I've taken statistics, but that sounded like a statistically significant sample size. But it sounds like the State Bar has adopted the view that we can't sample. We need 20% wouldn't be enough. We need a much larger sample size to verify the indigent, because it's such an obstacle. I want to make sure to reaching out to certain people. I want to make sure I really understand that is the view, and that's what the regulations state, if not the statute.
Yeah, I think that I will just note your point about it being an obstacle is this is where there's a little bit of an issue, is that a lot of other organizations actually, I think almost all other organizations do screen successfully. So that's one thing we're trying to be fair on that side too. But anyway, I know there's other comments, so I'll be quiet.
Yeah, actually, if there are comments, let's either place them in the chat, or if you can please raise your hand.
We have 3 hands that are raised.
Yeah,
Bonifay.
and that would be the best way to go forward. Thank you.
So Eric,
let's start with Eric, and then we'll go to Jim, and we'll go to Catherine.
Yeah, I was on eligibility and budget last year, and I believe this organization had either the identical issue last year or a very similar issue last year. And and we raised it with them in an eligibility review, conference. And I'm a little puzzled as to why they haven't been able to, basically up their game. This is not new, I guess, is the point I'm making for them.
Thank you, Eric. Jim?
Yeah, I was on the review committee this time around, and there's the issue that they didn't do it the previous year. There was the issue that this program used to be run by the court, and the court did income screening, and then they contracted it out, and the court quit doing income screening, and it sounded like this organization just did not place it as a priority. And in terms of sample size, 20% is inadequate. Plus, there was a problem of seasonality. There were 2 months. And we know sometimes these clients and their problems can vary by season. And so their sample was inadequate, especially when you compare it to most other programs who during the same time period managed to get screening information on almost all of their clients, not a small sample of their clients.
Thank you. Catherine, do you still have a comment?
Jim just said what I would have said.
Jim
but
just said it,
maybe
yes.
more. Yeah,
And
thank you.
in the chat, Pamela is underscoring what Jim said. I too am in that subcommittee, and I underscore what Jim said. So Will, does that help explain it for you?
Yeah, my puzzlement remains, as Eric was puzzled, so too am I, why they couldn't get it together, and if this is an obstacle. And I really love Jim's time to understand how the statistics work here, because I find it a fascinating subject, but I won't bore the commission with any more of that for now. Thank you.
Well, we are never bored with what Jim has to say, but we do have this the language here before us. And so if Eric, either of the Ericas would like to read this in, and we can move to a motion and a roll call vote.
Sure. Do you want to keep it's basically 2 different determinations. One is the pro bono allocation, one is funding for 2022. Do you want to make separate
I
motions?
think let's take them one at a time.
Please. Yeah, thank you.
So as it relates to 2022 IOLTA EAF funding, the resolution would be resolved that the Legal Services Trust Fund Commission finds the following 3 programs ineligible for IOLTA and EAF funding for grant year 22. Catholic Charities Diocese of San Diego, East Bay Family Defenders, Family Legal Assistance at Chalk Children's, and it is further resolved that the Legal Services Trust Fund Commission finds the remaining 103 applicants listed in attachment A to the memorandum eligible for IOLTA and EAF funding for grant year 2022.
Thank you. So do I have a motion?
So moved on that first paragraph motion.
I'll
Thank
second.
Thank you, Bob and Eric, and roll call vote, Dawn.
Agagi,
Yes.
Iskin,
Yes.
Asaraf,
Yes.
Ball,
Yes.
Bartleson, Whitemaster,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
Boschelli,
I'll abstain on this one. Thank you.
Connolly,
Yes, but I will abstain as to Klaska.
Du Bois,
Yes.
Delfino, Friedman,
Yes, except that I need to abstain for East Bay Family Defenders, please.
We're not there yet.
Yeah, we are.
That's what we're doing, Bob. We're moving on both of these.
That was not what I said. I said on the first.
Do you want
to take them separately was the suggestion before we got into this. So my
so
motion was
it's-
the first paragraph.
Carol took out the pro bono allocation. That was the suggestion, was to separate pro bono allocation from the eligibility. But if
I don't like doing yes and no in the same motion. I think it's bothersome. That's why I said what I said.
I
So
see.
then Bob, are you suggesting we have 3 separate motions here?
There's only 2 paragraphs on the displayed here. There's only 2 paragraphs. I don't know what the third one is.
So
First paragraph says, resolve the Legal Services Trust Fund finds the following ineligible. That's
Right.
paragraph 1.
Originally, Bob, there was a pro bono allocation was the
I'm aware
third
of that.
paragraph. I know.
That's deleted.
Right. So that's we're thinking, that's why we're saying 3. So it would be
But you're talking about something not.
ineligible
It's
is
been
1,
deleted.
eligible 2, pro bono allocation is 3.
Well,
So let's look at this. So I think what Bob might be saying is let's take out the further resolved. Is that what you're suggesting, Bob?
That's the second paragraph. That's not the first. I only said the first.
We understand.
We're not yet there to consider the second paragraph.
We understand. And everyone here is friendly with each other, so it's okay. So let's go ahead and separate it out. It does sound like it would be 3 then, Erica.
So based on that change, then the first resolution would be resolved that the Legal Services Trust Fund Commission finds the following 3 programs ineligible for IOLTA and EAF funding for grant year 2022. Catholic Charities, Diocese of San Diego, East Bay Family Defenders, and Family Legal Assistance at Chalk Children's.
Okay, so on this motion, on this very language, do I have a motion?
Yes, I would so move.
Okay, and do I have a second?
Second.
Thank you. And shall we move to a roll call vote, Dawn?
Aglagi,
Yes.
Iskin,
Yes.
Al-Saraf,
Yes.
Ball,
Yes.
Bartleson, Fightmaster,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
Bushelli,
Abstain.
Connolly,
Yes.
DeBose,
Question, did we just throw out the other motion?
No, we've tabled it and we'll be bringing it back forth.
Okay, all right, yes.
Delfino, Friedman,
Yes, as to Catholic Charities and Family Legal Assistance, abstain as to East Bay Family Defenders.
Mann,
Yes.
Meeker,
Yes.
Planthold,
Yes.
Rhinus, Savage, Schreiber,
Yeah.
Vanarelli,
Yes.
motion passes.
Thank you. And Bob, the reason why some of our commission members are abstaining is because they might have an affiliation to one of those
I
3.
understand.
Okay. So let's move on to the next motion.
So the next motion would be resolved that the Legal Services Trust Fund Commission finds the remaining 103 applicants listed in attachment A to the memorandum eligible for IOLTA and EAF funding for grant year 2022.
Very good. And so do I have a motion?
So moved.
I'd like to make the motion with a recommendation. We remove the word remaining.
Okay.
Okay.
Ah,
So moved by, does anyone have a problem with that?
I'm trying to
Yes, Chris.
raise my hand, sorry.
Yes, please go ahead, Chris.
I can't see anybody. So I just want to flag this issue. How do we do the abstentions for affiliations in the context of, 103 applications? Can we submit abstentions? Like how? Or do we just
Right.
announce
Right. In
them?
the past, we used to
Yeah.
send around that sheet, and then we would abstain. But I think what Brady, please jump in here and guide that conversation if you would, given the changes. My understanding is that folks are to just abstain at the point of their at the point of voting. But if I'm wrong with that, please clarify it, Brady.
Yeah, that's correct. Any voting where we're voting on a a list that includes an organization with which you have a relationship, your vote would be aye or nay, with the exception of name abstaining from X organization. And the result would be that if enough people abstain from that organization, it would either not pass or pass, depending for that organization. But of course, there are enough of you that rarely comes up.
Perhaps as a friendly amendment to that, going forward, maybe there is at the beginning of the year, of the commission year, there could be a list that's circulated. We can review that. We can get our affiliations back to the staff. And on the staff side, you can also have that roster before you in case we miss something and we don't see the totality of the 103 right before us at this moment, as a reminder, just to make sure that we're not missing anything.
Great.
We're happy to do that. We can collect that.
Okay, thank you. All right, Christian, does that help?
It does. I mean, I think that this list was in the materials that were circulated.
Mhm.
So I'm just going to spin through it, but I don't want to delay it any further. So anyway.
No, but it's a valid point and it comes up often. So I think if we can find a way to be able to balance it for everyone, it'd be helpful. All right. So we have Jeff who has moved. I think Bob seconded.
Yes.
Are there any other comments or questions on this before we move to a roll call vote? Okay, hearing none. Duan?
Aglagi,
Yes.
Iskin,
Yes, abstain as to Beit Tzedek.
Al Saraf,
Yes, I'll abstain as to Legal Aid Foundation of Los Angeles.
Ball,
Yes.
Bartleson, Fight Master,
Yes.
Bennett,
Yes.
Blakemore,
Yes, abstain as to Disability Rights California.
Boschelli,
Yes.
Connolly,
Yes, but I abstain as to CLASPA.
DeBose,
Yes.
Delfino, Friedman,
Yes.
Mann,
Yes, abstain as to Disability Rights California.
Meeker,
Yes, abstaining with regards to the Public Law Center. And for the record, I should have abstained for the Public Law Center on the partnership grants also.
okay. Feintold,
Yes, abstain as to Bay Area Legal Aid.
Rhinus, Savage, Schreiber,
Yes, but abstain as to the Impact Fund, Legal Aid at Work, Open Door Legal, if they're on, yeah, and I think that's it.
okay, thank you. Vanarelli,
Yes.
motion passes.
All right, very good. Thank you. And I think we have one final resolution to come forward.
So this actually pertains to the next agenda item, but it's for the pro bono allocation for the organizations that are to be found eligible or ineligible to receive that allocation in 2022. So in the attachment provided to the commission, 17 were recommended eligible. And as I mentioned before, Inland Empire and Learning Rights Law Center were recommended as ineligible. So the resolution would be resolved that the Legal Services Trust Fund Commission finds 17 organizations eligible for a pro bono allocation and 2 organizations ineligible. I don't know if you want to break these out into separate motions as well, given the prior comment about saying yes and no in the same motion. But
How does the rest of the commission feel? I feel that this is fine for it to be in one motion.
It's the same topic, so I think it's okay to have both yes and no in one motion, as opposed to suit 2 separate topics.
So let's go ahead and vote on this, please. Are there any other comments? No, okay, so do I have would someone like to move
So moved.
and a second?
I'll second.
I'm sorry, who was that?
I think Corey came in.
Okay, great. I'll do roll call. Aglagi,
Yes.
Iskin,
Yes, abstain as to Bate Sedek if they're one of the pro bonos, I forget.
Alsaroff,
Yes, and same as to Lafla.
Ball,
Yes,
Bartleson, Master.
Yes, again, I'm not sure. Law Foundation of Silicon Valley, I abstain if it's in there. I'm looking for it, but can't find it, so.
Bennett,
Yes.
Blakemore,
Yes.
Boschelli,
Yes.
Connolly,
Yes, but abstain as to CLASPA if it's in there.
DeBose,
Yes.
Delfino, Friedman,
Yes.
Mann,
Yes.
Meeker,
Yes, abstaining with Public Law Center.
Plantold,
Yes, abstain if Barry Legal Aid's on the list.
Rhinus, Savage, Schreiber, Schreiber. Chris, are you still there?
Oh, sorry, I was talking. Yes, I'm here.
Okay.
Yes, I vote yes.
Vanarelli,
Yes.
that's 16. And we actually have one more motion to the last, we apologize, it was not in the memo, but it's to the last agenda item. For discuss and approve eligible and ineligible applications. Erica, do you want to pop up that motion and I can talk about it?
Yeah, I have to pull it up so you can maybe
Actually,
guess.
let me just ask you, where are you ladies on the agenda?
We just voted on D, but we have to go back to C because there was one more motion
Okay, very good.
for C. So we apologize. And again, this was not in the memo because we've been trying to kind of figure out the logistics and the administration for the increased EF funding. And the eligibility, staff brought this recommendation to the Eligibility and Budget Review Committee previously at the previous meeting earlier today. And the staff recommendation and the committee approved was to allow with the EF, because it's such a substantial increase in funding, is to allow applicants to provide a 2-year budget proposal if it suits their organization, so they can better plan and hire, and programs that can use the increased funding more quickly and can gear up and hire, they can still have the option of submitting a 1-year budget proposal. So the committee would like to bring that that proposal to for your approval. And it reads, resolved, given the substantial increase in equal access funds, the Legal Service Trust Fund Commission allows grantees to propose a 2-year budget from 2022 through 2023 for the EF grant awards. Grantees will still have the option to propose a 1-year budget if it is more suitable for their program.
Eric, you have a question?
Yeah, so Dwan, I'm just trying to wrap my head around this. So, okay, so given the vote that we just took on eligibility for the 103 organizations that are now eligible, they're going to get an IOLTA award, right? And they're going to have to submit a 1-year budget for the IOLTA award.
Yes.
They're going to get an EAF award, and you're suggesting they submit a 2-year budget for that award.
Yes, that's correct.
And then next year, presumably, a lot of these organizations, maybe all of them, will also get another EAF allocation. And I guess we'll see what you're going to recommend there. But I guess there could be kind of overlapping. I mean, if you guys can administer all that, I guess it's great. It sounds kind of complicated.
Yeah,
but
we wanted to give programs kind of maximum flexibility. And we did check the legislation and check with OGC. And this would be allowable under the legislation, that they would be permitted to spend it over 2 years. So we wanted to provide maximum flexibility, but to answer your question, yes, it will be more work on our end to track but given the sizable increase, we thought that it would be a good gesture for grantees. And then we also wouldn't need to process carryover requests if there are large carryover requests or any carryover requests at the end of the 2022 year.
I forget, did we adopt a policy or at least an inclination or on carryovers for this year, like we did last year?
The eligibility committee has not, and that will be brought to the next time we meet in November. The eligibility committee will bring forth the proposal for budget modifications and carryovers into the next year.
Okay, thank you.
Okay, Catherine, and then Donna, please.
I just wanted to express an appreciation for the staff for identifying this and coming up with a solution. I think it will be very helpful to some programs. My understanding also is that this year's funding includes some one-time funding that might not be available in subsequent years, and this would allow the flexibility to more effectively use that money over a multi-year period. So I just wanted to speak in favor of the proposal that staff is presenting in this resolution. Thank you.
Thank you, Catherine. Donna?
Yeah, I was actually going to make a similar point that Catherine did. The increase of 50,000 to the EAF this year is anticipated to be more like 20,000 for future years. And this is an opportunity to allow programs to figure out the best way to utilize that money and do strong long-term planning. We obviously want programs to provide new programs, increase staff, and having that longer term vision when we know that next year's funding is likely to be more than current year, but less than what we've got coming for 2022. This was just giving them that extra flexibility.
And we do plan to build into the budget application a question for them to justify why they'd like to take it over 2 years, and that will be elevated to the eligibility budget review committee to determine whether it's a compelling reason and to approve that. So this is just so that they can have it's not a blanket approval, it's so they have the option, and then the committee will have a recommendation that will be brought to the commission.
Well, I want to echo Catherine's sentiment. This is the proactive nature and the forward thinking of the staff is applauded on this. So shall we move forward to a motion? Would someone like to move?
Catherine moves the resolution.
Thank you. And a second?
A second.
Thank you, Luis. And roll call vote, please, Dawn.
Aglagi,
Yes.
Iskin,
Yes.
Al-Saraf,
Yes.
Ball,
Yes.
Bartleson, Whitemaster,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
Bashelli,
Yes.
Connolly,
Yes.
DeBose,
Yes.
Delfino, Friedman,
Yes.
Mann,
Yes.
Meeker,
Yes.
Kleintold,
Yes.
Rhinus, Savage, Shriver,
Yes.
Vanarelli.
Yes.
Motion passes.
Okay, very good. Thank you. All right, well, at this point, we actually thought that this first half would have taken about 2 hours. So congratulations to the commission and all of the reporting out. We did this in about an hour. But at this point, I'd like to pass the baton over to my co-chair to run.
Yeah, thanks.
The rest of it.
Thanks, Bono. Startling efficiency. Kudos to you.
Yeah, it's amazing.
Or else everyone's asleep today. And if you are, enjoy your nap. So we'll move on to, I guess, item 5E on the agenda. I think that's where we are. And this is Christian and Chris. The homelessness prevention grants.
Thank you. Good afternoon, everyone. This is Chris McConkey, Senior Program Analyst. Christian, is it okay if I dive right into the report?
Yeah, for sure. And happy to sort of jump in as needed.
Great. I'm gonna share my screen since we have slides. Make a good presentation view so it's a little bigger for you. Okay. Does that look okay? Is that big enough for everybody?
Yes, good.
Okay.
Thank you.
Good. All right, so the legal services, this is the Legal Services Trust Fund Commission Homelessness Prevention Funds Committee report. And then I'll present the background on the the statutory authorization for a new source, 2 new sources of funding, with the HP Funds Committee members jumping in to help fill in any gaps. Let me just fix one thing. Okay. Okay, so the overview is, I'll give you the background on Assembly Bill 164, which is creating homelessness prevention, a new round of homelessness prevention formula grants and homelessness prevention competitive grants. The permissible uses I'll talk about, which are very similar to the last round of HP formula and competitive grants, but there are a couple of changes. And then I'll give an overview of the formula grant requirements, the competitive grant requirements, and then the HP, the Homelessness Prevention Funds Committee, in its memo to the Commission dated today, recommends a timeline for the formula grants, a separate timeline for the competitive awards, and it recommends a couple of resolutions that would delegate authority to staff and or the committee to make sure that the grants can go out on time. So, and feel free to ask your questions as I go along. It may be helpful to everyone to hear the question and have it answered right away. So Assembly Bill 164 amended the Budget Act of 2021. It allocates $40 million this year, this legislative budget year, to the Judicial Council to distribute to QLSPs and support centers through the Legal Services Trust Fund Commission. And then Dwan, just correct me if I misstate this in any way, but our understanding is that the Department of Finance has confirmed that an additional $40 million will become available over the next 2 years that could facilitate 3-year awards with a total 3-year combined pot of funding of $80 million. But $40 million was appropriated for this year.
And we just received this confirmation. This is hot off the presses, and this is why it was not shared at the last committee meeting.
And so it's not $80 million that has been appropriated and is available for encumbrance now. It is $40 million this year, and then it'll either be another $40 million 1 to 2 years from now, or 20 million and 20 million. But that the whole 80 million that the Judicial Council and the Commission can reasonably expect that it will be 80 million over 3 years, and that 3-year awards would be appropriate if the Commission wanted to go that route. It funds qualified legal services projects and support centers to provide, and I copy and pasted these words right from the bill to avoid misstating them in any way, but eviction defense. And the next slide has a rather expansive list of examples: other tenant defense assistance in landlord-tenant rental disputes, and services to prevent foreclosure for homeowners. AB 164 provides up to 2.5% for administrative costs. So that would be up to $1 million for this year's $40 million appropriation. And then 75% of the remainder, which would be at least $29,250,000 for this year's appropriation, would go out by formula grant, and then the remaining 25% of that, what was left over, which is up to $9,750,000 for this year's appropriation, would go out by competitive grant. So I've highlighted on this slide the permissible uses that are new to this year's version of the homelessness prevention formula and competitive grants. So if it's not highlighted, it's more or less exact. I think it's exactly the same language that appeared in the last round. So they would fund, both the formula and the competitive grants would fund, quote, eviction defense, other tenant defense assistance, and landlord-tenant rental disputes. And then new this year, or services to prevent foreclosure for homeowners. And then it says this includes, and it gives a long list of, with a catch-all at the end, pre-eviction and eviction legal services, counseling, advice, and consultation, mediation training, renter education and representation, legal services to improve habitability, increasing affordable housing, ensuring receipt of eligible income or benefits to improve housing stability, and then new this year, legal help for persons displaced because of domestic violence, and then the catch-all homelessness prevention. This applies to both grants. So the formula grant has some unique statutory language. So this is, again, the 75% after admin costs, the 75% would go up by formula grant to QLSPs and support centers that were found eligible for 2021 IOLTA funding. That is, they must have applied for that and have been found eligible. The statute says they must currently provide eviction. They must already be providing current eviction defense or other tenant defense assistance in landlord-tenant rental disputes as set forth in this provision. So staff investigated whether it was the case that they have to be doing unlawful detainer cases, and that's what the legislature meant, or was it that they could be doing any of these permissible activities that these grants could fund? And it's rather clear that what the legislature intended, the statutory interpretation that it makes the most sense is that they could be doing any of these activities that these grants are meant to fund. And that is the as set forth in this provision language. So each eligible applicant's share of the formula grant has to be proportional to its share of 2021 IOLTA grant funding when looking at those programs that apply for and are found eligible for a formula award. No applicant receives less than $50,000 unless it elects to receive a formula grant of less than $50,000. The grant can't supplant existing funds, and the Judicial Council and Commission need to distribute the funds as soon as practicable. For the competitive awards, it's the 25% that remains after admin costs. It's to provide eviction defense, other tenant defense assistance, and landlord-tenant rental disputes, or services to prevent foreclosures for homeowners. Again, as set forth in this provision, so that catches all of those permissible activities to meet the needs of tenants not addressed by the formulas provided in subdivision A. This one also should not supplant existing funds, including the formula allocation, if any. The commission, the statute specifies the commission must make award determinations that these grants should give preference for legal services organizations that serve rural or underserved communities, and that any funding left over from the competitive grants will be distributed by the same formula that we use for the formula allocation, but it doesn't have to have a $50,000 funding floor. I'm going to pause after this slide before showing the timelines, just for questions sort of about AB 164. But the very last thing staff wanted to put in here is the funds are available for encumbrance or expenditure until December 31, 2024. The State Bar will, as usual, will be making annual reports to the Judicial Council. These particular grants happen to be supported by federal funds. So it's the federal funding source is the Coronavirus Fiscal Recovery Fund of 2021. So there are some unique requirements for both the State Bar and programs that come with receiving federal dollars. It is likely they will have to submit quarterly program and financial reports, I believe, to facilitate the State Department of Finance's reporting to the federal government. For some of them, it might trigger a single audit, depending on how much they get or how many other federal grants they have and the like. So staff is exploring with the Judicial Council and others what the federal requirements will be for programs. And staff has heard that programs can submit multi-year budgets. So I'll pause here. The remaining slides are all the timeline that the committee recommends and the resolutions, but I thought it would be helpful to kind of answer everyone's questions about the statute.
Chris, Catherine and Jim have their hand raised.
I'll do Catherine first because I don't know who raised that.
Oh yeah, I took down my hand because you answered my question with your last sentence, so I'm good, thank you.
Of course, yeah, great. And then Jim.
Jim,
And I'm sorry, Jim, you're on mute.
Any further definition or explanation or clarification of what is meant by underserved populations?
Not in Assembly Bill 164, unfortunately. So it is left to it is left to the commission and I assume the State Bar Board of Trustees and Judicial Council to interpret that. Any other questions about the formula grants and competitive grants for homelessness prevention? Generally, it's very similar to the last round. They just added a couple more permissible uses and the amount of funding is different.
I don't see anybody has their hand raised. And I'll just add the encumbrance, because we get this question a lot. What does encumbrance mean? And with direction from the Judicial Council, encumbrance for us means when the State Bar has executed our contract with Judicial Council, then we've satisfied this requirement.
All right, thank you, Dwan. Okay, so
Claire
oh,
has
yeah.
her hand up. I'm sorry.
Oh,
Claire,
great. Yeah.
And Claire is a member of the public. Would you like to unmute yourself, Claire? Claire, I think you're
Claire,
muted.
just in case you started talking, we still can't hear you, but whoa.
Okay.
We have plenty of time, so.
Hopefully you can hear me now.
Yes, now we can. Hi, Claire.
Unmute button is delayed, just so you all know. I only
Okay.
got 2 seconds ago, so I was in the process of typing a note to say I can't unmute myself. Thank you all so much for allowing me to join the meeting today. As always, I learned so much participating. For any of you who don't know me, in addition to be a legal service funder, I run an entity called the Legal Service Funder Network, which has over 80 Bay Area organizations involved. And my question is that I was delighted to see in the second slide a call out specifically for domestic violence, which leads me to believe that organizations that are not specifically focused on housing will have an opportunity to apply for these funds, which I think is fantastic because while our LSFN fellows, about 25% are actually in organizations that focus on housing or housing departments, 100% of them are doing some form of housing work right now. And so I think that many LSOs that traditionally have sort of felt that they might not be candidates, if in fact they are going to be considered, I think that's going to be a really important part of the messaging. So thank you so much for the opportunity to speak.
Thank you, Claire. Okay. All right, so the Homelessness Prevention Funds Committee met on July 30th to discuss and evaluate several iterations of, or staff described several iterations of timelines to distribute the HP formula grants, because this is of both of the grants, this is the one where AB 164 says that the Judicial Council and the Commission need to distribute it as soon as practicable, quote unquote. So staff worked through and then described to the committee an October 1st grant period start date, whereas everything that needs to happen before the grant goes out is done by October 1st, and that's when the grant begins. Staff described a November 1 start date and then a December 1st start date. The October 1st and November 1st start dates, we're going to leave programs about 2 weeks to do the application, maybe 2 weeks to do a budget, and very little time to hire. By the, or at least they would be like, if they had any trouble hiring, because it requires expanding their programs, they're not supposed to supplant existing funds, there would be a high risk of like a dead time or downtime in the beginning. So having heard from, having consulted with the Judicial Council, having consulted with the Legal Aid Association of California, and then having thought through it with the committee, staff recommended, and then the committee agreed that a December 1st grant period start date would be the as soon as practicable timeline to distribute the formula grants and that doesn't actually give State Bar staff any more time to perform their pieces, the application review or the budget review or anything. It gives all the time, the extra time that was achieved from going from like October 1 and November 1 to December 1 to programs to think about what the projects will be, to write the application, and to submit a budget and to hire. So I'll do a quick, this is in the memo, but I'll just do a quick walkthrough of the table, because there are some delegations of authority to staff members and to the committee that are built into this timeline. So I want to go through it row by row, and then the slides at the end of the presentation actually have the proposed resolutions that would delegate the authority. So to distribute the funds as soon as practicable, the application would go out this Monday, which is October 16, and the application is 99% ready to go. So it would be ready by the end of the day on Monday at the latest. This timeline would give programs about a month to submit the application. That's also to accommodate summer travel, and that they will have to think about how to create a new 3-year project or expand an existing project over 3 years. Staff would review the applications for eligibility. So there's a resolution that proposes that the commission delegate authority to staff to review and the committee to approve eligibility for formula grants. After a finding of eligibility, staff would run the allocations. Each program would find out, each eligible applicant would find out what their allocation would be. They'd have about 3 weeks to submit a budget. There's a resolution that proposes delegating authority to staff to review and approve the budgets. And that's again to get the funds out as quickly as possible. And then the grant period would begin on December 1st. So I'll pause here before showing you the timeline for the competitive awards to see if there are any questions about this timeline.
Chris, Herman has his hand raised.
Hi, Herman.
Yes, is September the 10th, is that a hard date? Or if Herman submits his application 3 hours later or a day later, you're going to accept it?
I think we would want to handle this consistently with how we typically handle application due dates. I think we tell programs that it is a hard deadline insofar as we would have to get we'd have to notify the committee or the commission that an application arrived late, and then it would be subject to committee or commission. Now, correct me if this is wrong, Gwan. It would then be subject to commission or committee like discretion as to whether or not to accept a late application.
Yes.
So it would be hard in that respect.
So
So, yeah,
September 10th is not a hard date.
Well, staff doesn't have the authority to deny eligibility. So exactly what Chris said, if an application came in after that, we would let the application go through, and then we would elevate it to the committee to say, this is a late application. Would you
Well,
like
I
to
put
accept
in
it?
formula application due on September 10th, but what you're saying is not due on September 10th.
It would be a quote late application. So if the committee or commission decided to accept a late application, then it would be allowed.
Well, why are we having a date if you're saying if it's late, we can still accept it?
Oh, only just because staff can't tie
have
the
the
committee or
authority.
commission's hands.
Yeah.
So it's up to the committee or the commission if they want it to be a drop dead deadline.
So
Which
how
you could
late-
decide-
how-
which you could
how
decide
late-
here.
How late is late?
Usually it's late if it doesn't come in by 5 p.m. on the due date. So it would be late if it came in at like 5:15 p.m. or
So September 10th at 5 p.m. is not a hard date. It's not a hard time.
Hey, Herman, I'm not following why you think it's not. I mean,
If you say that September 10th at 5 o'clock is the deadline, anything after that should not be accepted.
I see. I would say Brady raised his hand, and I have a suspicion he wants to weigh in.
We have a couple of hands up. We have Judge Seligman, who's been waiting patiently. We also had Brady in and now out. So maybe Judge Seligman and then Brady.
Yeah, the concern I have is this is a very short period of time, and it includes the period of time when many people are likely on summer vacations and Labor Day weekend. So I'm a little nervous about squeezing people, and there's two alternatives here. One is to maybe add a week or two more time, take that into account. And in addressing Herman's concern, my view of what a hard deadline means, and I'm a judge, so I have this all the time, is absent a jurisdictional problem, if good cause is shown, an exception can be made, not simply willy-nilly. There has to be some legitimate reason why it was late. And sometimes it's something like my computer crashed the day I was supposed to be due, or, you know, I've been on leave the last month and I just got back yesterday. That might be legitimate as opposed to I just spaced out. So the 2 points that I wanted to make is we should maybe consider putting in a little bit more room and time, and then maybe being a little bit more explicit about how hard that deadline is. Now, I agree that if we don't say anything and the commission just grant some late ones without any explanation, that sort of invites the appearance of some favoritism or lack of any standard.
And did Brady, that was helpful for me to hear. Brady, did you still have your hand up? I can't see you anymore because I'm sharing my screen. But
I was just going to provide more context for Herman's question. We've gone through this in the other programs. We have a standard that goes to the commission. I believe it's extraordinary circumstances. So, you know, there's a deadline. The programs recognize that they're going to have to make a showing, and that they're certainly not guaranteed if they don't meet the deadline, whatever the deadline we set is.
Yeah, so I mean, I can't speak for Dwan or Erica Carroll, but I think staff is, you know, probably happy to enforce whatever standard the commission and the committee adopt as far as how to handle the deadline. Because I think staff could say if it had permission from the commission or the committee, automatic, you know, that if it comes in after like 5 p.m. Pacific time on September 10th, it's an automatic rejection, and send an automatic rejection email. But I don't think that's how we've handled other grants. So that would be like a new practice.
Yeah, we're just continuing the ongoing practice. If the commission decides otherwise, I would suggest that maybe have the rules committee think about deadlines and how firm and because this is kind of, this has been the office practice, and this is for us to at least let them submit it, and then it's elevated to the respective committees to determine whether you accept that late application.
And Eric.
So with respect to Judge Seligman's comment about possibly extending this deadline, just a question. I'm a little concerned about the pressure on staff that would create, because we do want to get these grants out by December 1st. So question, how is this deadline kind of known in the community? Have we socialized this at all, Dwan?
We've shared that, you know, we'd like to get it out as soon as possible. There have been programs that have been calling me to ask. So I floated to some programs a date, but I said, obviously subject to the commission's approval. And then I did promise programs that right after this commission meeting, we would send them an email either later today or first thing on Monday to let them know about the timeline.
Maybe a follow-up question is, how difficult is it to put together an application for a formula grant?
I think a lot of it will be recycled from the last application, but the thing is, there's that supplantation language in terms of if they already have previous funding, they can't use this to supplant that, and so I think that's going to be hard for programs to figure out staffing. So a month is quite tight in terms of figuring out what the proposal is, and it's hard for them to coordinate. So I think that kind of depends. No. I mean, that's very hard for us to answer, given that we anticipate probably 80 applications coming through.
Well, how feasible would it be for staff to extend the deadline a week or so?
If you wanted to get it out for December 1st, when we contemplate an October 1st or November 1st release, when we extended it to December 1st, we gave all that time to programs. We didn't give staff additional time. So if we're going to stick with the December 1st, it would be really, really difficult for staff to then do the review of applications and then the budgets in this timeline. I would say if you wanted to give programs more time, then we should move the December 1st date to perhaps January 1st.
Yeah, is there magic to December 1st? I mean, is that just
there's not magic, but in 2019, that the legislation that was passed in 2019 had the same as soon as practically language. And we distributed the funds during that cycle on October 1st. And the reason we were able to do that is because first the governor signed the budget earlier that year. And we also had a heads up earlier. There wasn't a competing legislation. This year, we did know the direction was going to go in because of the other pending 1487. And then on top of that, the governor signed it late. So we were shorthand. We calculated about 5-7 weeks. And so that's why we can't do the October 1st, but we were trying to stick to that October 1st because we know that that was acceptable with the legislature and that timeline was fine. It's just October 1st was not tenable given how late the governor signed it. So then that's why the committee then contemplated November 1st, and the November 1st still felt really time pressure and didn't give programs enough time. So then they went to December 1st.
Why not just consider a 2-week extension across the board so that the December 14th or 15th would be the deadline? Gives a little bit more room given the holidays in the summer. And I don't think that does violence to any of the deadlines. It's still incredibly prompt in putting out an enormous amount of money.
So Pamela and Catherine have their hands up. Pamela, go ahead.
Okay, now I'm sorry, going to speak. I would just kind of suggest that staff not plug in language that will give them a reason to be late. Because you all obviously have work to do, and just be firm in terms of this is the deadline, December 14, December 1. But don't give too much wiggle room. Let them be timely so that you can do your work timely as well. Thank you.
Catherine?
So my question is, so from a applicant perspective, is there anything else due to the bar, like budgets for the cycle that was just approved at the same time? And what is that time frame? So to me, schools are starting earlier. I feel like people are going to be more back and people know this is coming. But if it's being done at the same time that you're supposed to do these very large budgets for IOLTA and equal access, then I think that's a significant problem. So could you just speak to that?
Sure. So for IOLTA and EF, we plan to release budgets at the end of the month, and then they have 30 days to do it. So it's going to go into September, so there will be an overlap.
So I honestly feel like this overlap so people are going to get this IOLTA money plus $50 million or some number like that of additional equal access money for which they have to be developing a program. And then on top of that, they're supposed to be thinking about how they're going to spend their share of 30 million. I mean, as someone who ran a large program, I mean, that is like mind bending about how you get all of that work done and allow you to continue to serve clients. So, I mean, for that reason, maybe supporting what Judge Seligman said, it's like somehow there needs to be a little more space, I think, to be able to allow all of that to happen. And then my last note is, I appreciate everybody's interest in the extension and all of that. It feels like deja vu to me. I believe we had a very long discussion about a month ago about this, and we agreed that staff was going to put together some recommendations and come back to the Rules Committee about that. So I'm hoping we can just wait until staff has a moment to breathe, if that ever happens this year, to present us with something about kind of what is a timeline and what are the reasons things could be extended. So, thank you.
Bonafé, you have your hand up.
Yes, to the point that Judge Seligman just made and Catherine made, looking at this timeline, though, the issue is critical. So I can see why we want to get this money out as soon as possible. But this, along with everything else before the programs and before the staff, I think it's accelerated. So I think there was a January 1 date, Duan, that you had mentioned. I would even propose February, but let's give a little bit more time here. This seems too accelerated.
Duan?
Yeah, so if you're amenable, yeah, I would really suggest the January 1st instead of the mid-December, just because it's easier for us to report out. We usually don't do a mid-month distribution. It's just hard on our reporting and our fiscal everything. Even having this tacked on a calendar year, we have to really adjust our administrative to account for this. So if you are flexible, then I would really suggest the January 1st.
So Chris?
Is it
Yeah.
Chris or Christian? Okay.
Yeah, so I guess just a couple of thoughts. One is there are sort of three competing priorities, just to put this into some perspective. There's the programs and what the programs are able to do. There's staff and what staff's able to do. And then there's the legislature and what the legislature expects about this money going out the door. There is this concern about the moratorium expiring and that basically increasing a need on a very, binary timeline. And so when we met as a committee to discuss the timeline, we were sort of mindful of the pressure that put on staff. And this was the timeline that staff sort of expressed that they were able to do it. I'm sort of mindful that we don't want to leave anybody out as a program for an inability. But I guess I want to get back to this question about whether formula funding is really burdensome in this way for the programs. I don't presume to know, but so I'm just soliciting a response from the knowledgeable parties here for the formula funding, because I'm generally trying to be supportive of what staff is able to do, given all these incredible pressures they've been under to get a lot of stuff done. But I would only comment that the work of the HP committee last year, critique is too strong a word, but there was a lot of commentary about how we weren't getting the money out fast enough. So I think that did inform the timeline here. So now it seems like everybody is sort of a little bit more relaxed about the timeline, and I guess I'm curious about that.
Well, I think we have different circumstances here. I mean, we do, as Catherine pointed out, we have this year the very unique additional EAF funding surplus or additional funding that's going to require new budgets. So that's an additional burden on programs. And then, as Dwan pointed out, the application is going to have to specify how this particular application will not supplant existing fundings. They're going to have to think about that. September 10th is less than a month from now. So I don't know.
Well, Eric, Selena's on the phone. There's a message in the chat. Maybe what she has to share out would also help inform this discussion further.
Yeah, I don't see her. Can you read her chat? Because I don't.
She literally, all it says is that she's on the phone and would like to be on
Oh,
staff.
all right. Well, yeah, let's admit her to speak. Selena, go ahead as soon as you're admitted.
Can you hear me okay? This is Selena.
Yes.
Oh, perfect. Thank you. And I apologize for the road noise. I'm actually in the car with my family. Yeah, I just want to reflect back on the, kind of 2 weeks versus 4 weeks for the RFP for the formula grant. We reached out to members of our community to get a sense, and everyone said 2 weeks was too tight, not because of the amount of the time that the formula grant application would take to do, but because I think Chris mentioned, so many people are out on vacation, and as Judge Scheligman mentioned, we've got the Labor Day weekend as well. But everyone thought that 4 weeks was plenty of time because they do recall that the formula grant application from the last time around was very simple. And again, on how urgent it is to get the funding out, I think that we've passed there's no way we could get it out October 1st. I think November 1st would be a real crush for staff, and I think that wouldn't be kind to staff or to programs. But I do think that December 1st is reasonable, and it really just comes down to, I think it was Chris who said, balancing the kind of needs of programs and staff versus the legislature's wish that the funding gets out fairly quickly. I don't know that a delay of a month is kind of a magic number difference, but because the state budget cycle started on July 1st, this will feel and look like a 6 month delay to getting money out. So if there's a way that we can get it out on December 1st and it doesn't seem additionally burdensome, I think the legislature would appreciate that because it does reflect their urgency. But moving on into January or February feels like it's less urgent. And also as the eviction moratorium ends, you know, that will be kind of too late to spend the money for that purpose. So I'll go ahead and mute myself, but I just wanted to kind of give additional information on those pieces.
Yeah, thank you, Selena. That's very helpful.
If I can just follow on with that, Selena. So a January 1 date that Dwan was just mentioning to help kind of take the staff into consideration. How does that feel from a community perspective, would you think? Did we lose her?
You did not lose me, but I didn't hear that because my child was talking. What was said?
No worries. I was just asking if we were to take the staff perspective and just tack on an additional 30 days to January 1, how would that, do you think the community would react to that?
I mean, I think for organizations, it might be easier because a January, I mean, you know, easier in terms of the budgeting. January start date is a clean calendar year. And I didn't hear anyone rushing to say they needed the money right away. If they know early enough how much funding is going to go out, then they'll be able to go ahead and post positions and hire if they know how much budget they're getting. So I think programs would like a January 1 start date. And for me, it's really just balancing the legislature's desire to get the funds out quickly and how we would message that, you know, programs could be ready to go and potentially hiring and ready to start programs on January 1st, rather than kind of still ramping up in January.
Okay, thanks, Selena. We have a couple more hands raised. So Zahira, and then Will, and then Dwan.
Thank you so much, and thank you for this conversation. I'm wondering if what I'm about to propose has ever been done, but if this would partially kind of solve and address the issue related to the legislature. But I wonder if about the timeline that has a January 1 start date that allows for the reimbursement for expenses that were incurred in December. So I'm curious about that, and if that's something that we could allow for, because to Selena's point, you know, programs are going to be doing work in terms of hiring and all of those types of things, and the allowing for expenses back to December allows us to communicate to the legislature that work can actually start starting December, but we've set it so that organizations can start their work in January, but it allows us to have a little bit more, you know, flexibility in terms of when some of these things are occurring.
Dwan, do you have an answer to that?
I don't immediately. I know our PL grants allowed them to kind of retroactively, and I can't recall right now how the grant agreement was, so we'll have to look into that. But I do want to just clarify that my January 1st suggestion was only in response to Judge Seligman's December 15th, and it's not to buy staff more time. We're comfortable with the December 1st. I was just thinking purely administrative. To have a mid-month distribution is a little awkward and hard for our reporting. So if we wanted to give programs 2 more weeks in December, my suggestion was then just to go be clean and do January 1st. But I wasn't suggesting because, you know, it would help staff out, but we're comfortable with the December 1st.
So Will, your comment?
Yes, I just wanted to respond that I am one of the people who pushed for it to go out as quickly as possible last year, and I would continue that sentiment into this year. Staff and the committee has indicated that they can make this schedule happen. And while I am sensitive to the needs of administrative personnel regarding accounting, having had to do a lot of tax accounting this past few months, I am more sensitive to the needs of the people who would benefit from this money getting out a month sooner. And so I'm really in favor of what the staff has indicated they can accomplish successfully. And the only concern I have is if there are not enough applications, or if for some reason the programs can't step up in the way that Selena suggested, that maybe there should be some contingency for allowing the staff to extend the deadlines appropriately to reach that January 1 date. But otherwise, I am strongly in favor of this quick schedule and really appreciate it. Thank you.
Thanks, Will. Duan, did you have more to say?
Yeah, I just, in response to extending the deadline, because it's formula based, it's really hard for us because we have to look at, it's like IOLTA and EF, we need to look at to see how many programs are eligible and then run the formula. So it's hard to save that money when if we run the formula based on 50 programs and then we've already allocated that 75%, we can't then find another 10 programs or 5 programs eligible because the money would have already been allocated.
So a number of the commissioners made comments about extending deadlines, thinking about the sensitivity from the program's perspective. I'm hearing Selena say that essentially the September 10 deadline seems workable, if I heard Selena correctly. It was 4 weeks. It was a little less than 4 weeks, but it's close. So let me ask Chris and Duan, did you want to consider formula grants in terms of a resolution, formula grants and the RFP separately, or do you want to consider them together?
Separately, please, because the RFP has a set of different issues.
Well, should we have a discussion about all of them first?
I see what you're saying.
Yeah.
All right. Judge Seligman, go ahead.
Actually, sorry, Eric, before we go to Judge Seligman, I think Judge Jaskol also has a comment in the chat.
Oh, thank
Sorry,
you. Thank you. My voice sounds kind of funny since I'm home with a cold. So I was just wondering if the timing, and this may be a little speculative, but if the timing is affected by the recall, and I've noted that there are some surveys that seem to suggest that it might be a little bit close, and I don't know if the funding could be affected if a different governor is in office. I don't. I realize that it's legislation, and in theory that shouldn't be affected by who takes office. But is there an argument that the sooner we get this out, the better, in case a new governor takes office who may not be so favorable to this funding?
You mean for the $40 million that would be coming in the next 2 years, as opposed to the $40 million that was already appropriated?
I don't know what might happen. I'm just sort of suggesting that. I don't know.
That's a good question. I couldn't even opine on.
Yeah, I don't know when. I mean, the recall is middle of September, and I don't know when, if it succeeded, I don't know when a new governor would be inaugurated.
Well, Donna, Judge Seligman, go ahead, and then Donna.
Yeah, just on that point, if this money is legislative, I don't think the new governor could do anything to it immediately. And there's also no physical way we could possibly get anything done before the recall. So I think it's sort of a moot question. My only point was, as I understood what Selena said, we should at least give folks a full month. Right now, if we release this August 16th, they get about 3 weeks. So given the holidays and all the rest, I still think, and it's consistent with the dates we're talking about, we ought to at least give them a full month to consider this, get their application in.
So would that be arguing for January 1st?
Well, I mean, at minimum, that would mean putting them off until September 13th or 14th. But I would really, if you count 30 days, that's 28 days. Give them to the end of that week, which would put it to September 16th. So at least they get enough time, get a full month, notwithstanding a holiday. I'm just worried it's really squeezing people.
Mm-hmm.
Yeah, August 16 through September 10 is 4 weeks exclusive of like the weekend that comes right after. It's a Monday, August 16th, through Friday, September 10th. It's 4 like business weeks, but they're losing a weekend and there's a holiday in there. It's 4 Monday through Fridays.
It's actually less than 4 weeks. It's 3 weeks and 3 days. So it's really tight.
I think what I heard Dwan saying is that if you're going to start going beyond December 1, you might as well go to January 1. Dwan, is that right?
Yeah, that was my, if you're gonna go mid-December, then let's just do January 1st. But then I guess I hear Selena's point that within this calendar year might be a good sign. Donna, I don't know if you have.
Yeah, Donna, you had your hand up, so go ahead.
Yeah, so just to respond first to what you're talking about right now, I agree with Chris. August 16th, this coming Monday to September 10th is 4 weeks, and that's what Selena had indicated the programs were comfortable with. When it comes to the issue that was being discussed earlier on the recall, I think we need to focus not on the recall, but on the fact of how important it is to get the money out quickly. We all know about the end of the moratorium. We know about the increased need for legal services, and that's got to be our guiding factor. What may or may not happen politically cannot be the driver on this one. So maybe Selena, if you can confirm that the 4-week period from August 16 to September 10, is that consistent with what the programs thought was acceptable, or would they need an additional week?
Selena, are you still in range?
Yeah, are you able to hear me okay?
Yeah.
Perfect. Yeah. So at least we talked to a number of programs represented on our board, and I think I talked to a few others just to get a sense of specifically 2 versus 4 weeks, because 2 felt tight to me, and they all said 2 was too tight, but 4 was fine. I think programs would be fine with more time than 4 weeks, but if the main concern from the commissioners is that programs need more time, what LAC can do is, as soon as the RFP is posted, we can do a ton of outreach, not only to executive directors and those listed in the Smart Simple contact system, which the State Bar accesses, but also to other senior staff at organizations to say, hey, this was just released. Want to make sure you work on it now because you have exactly 4 weeks. And I do know that some organizations, they told me that they didn't see the last time the HP was released in Smart Simple. So, there may just be some people who are the Smart Simple contacts who don't, realize the tight turnaround. So we are happy to do a ton of extra outreach with the goal of getting everyone who we presume to be eligible to apply for the funds. And we can also look at who currently receives HP grant funding as a really good guide of making sure that all of those are applying for HP 3.
With the purpose of the outreach, let's say we enact a resolution approving this timeline today. We're not going to have another commission meeting till November. You do a lot of outreach and you find out that this deadline is not workable. Is that what you're proposing, whether it's workable or not? And if the answer is
no, it's to get them to apply. And I think that State Bar staff is always very kind to programs to say, oh, the deadline is this date. And I think that LAC is in a position where I can tell executive directors and their senior staff, get it in on time. Do not be late, because this is a formula that we don't want to hold up. It's such a significant amount of funding that we don't want to ask State Bar staff to seek commission approval to accept late applications. And that's something that we can do in kind of a less kind way of saying, get your applications in. And I have communicated with State Bar staff in the past where they'll let me know which ones haven't applied yet, but they should have, roughly a week out. And we've done additional phone calls and emails to get them to apply.
Okay.
I just wanted to add, just because you haven't actually seen the next slide yet, and in all fairness, to help inform the discussion, the next slide is the competitive grant timeline, and it does overlap with the formula grant timeline. Not all programs will apply for competitive awards, but those who choose to will be juggling both to some extent. And I can show you the next slide, but I'll just say out loud, the recommended competitive grant timeline, the application would become available around September 1st and be due back on October 1st. So for those programs that chose to apply for both, there would be like a 2-week overlap where they're working on 2 applications. I just wanted to flag that.
let me point out the Claire's comment in case people haven't seen it in the chat. Claire says, as a funder who receives more than 100 applications from LSOs annually, I concur with Selena's comment that 4 weeks is sufficient for applicants to prepare their materials. And Judge Seligman, you also made a comment in the chat about your calendar being off. What was the significance of that?
Only that when I said it was less than a month, I was looking at the 2022, not this year. So actually, I agree with the calculations that were given, and I agree with Selena's suggestion that a month is sufficient. If she's confident in that, I am too.
Okay.
And I think, did Bonnie have a comment?
I see a note in the chat that's not substantive. Does anybody else have a comment, or else I think what we should do, unless there are more comments.
Catherine Blakemore just raised.
So
her hand.
I guess I actually appreciate the discussion about, kind of the legislative importance of this. So now you have programs submitting a budget for this large $50 million within the same time period. And now you have 2 other grant applications are due. So is there flexibility about when budgets can be submitted on the large amount of new equal access fund? I mean, I guess people will do what they're going to they're required to do, but I don't know. Maybe I was just a very slow plodding person, but that is a lot of work to achieve within the same 4-week period of time.
Well, can I jump in on that? I just wanted to, and then I wanted to add that so the application for the formula grants would be due by September 10th, and they would know what they would get an estimate of what their allocation is if everybody applied, which not everyone will. So the real number that the eligible programs get will actually be a little bit higher. And then their budget forms would get released in mid-October and be due back at the end of October. So in theory, they could have September and early October to think about what their budget might be before they have to submit it. But that's not to like invalidate Catherine's
Are you
point.
talking about the equal access budget or the budgets for this?
That's for the formula grants. Yeah, the budgets
No,
happen.
I'm talking about the equal access formula grant, not the housing.
Oh, great.
Grant. So when I asked earlier, Dawn said that during essentially during the first 2 weeks of this cycle, programs were also going to be able to have to submit the budgets for the equal access fund grant. Then they have to submit the form, then they have to submit their application for this. Then just what you said added another task. They have to submit the budget for the formula grant for the housing prevention. And if they're also applying for one of these, application grants, then they would have to do that. So within this very short period of time, all of that has to be done in addition to serving clients and everything else that programs do. So that's why I was sort of saying, okay, so the legislature thinks this is important and the money needs to go out. Is there flexibility about when the equal access budget grants could be due?
So Juan, go ahead.
Yeah, I'm going to respond. The IOLTA and EF, it's a really tight timeline for us we have to do that 30 days so that there are steps that the staff needs time to review, to elevate it to the committee to make the November, I believe 13th this year, to approve all eligibility and budget, so that it takes us at least a month to process grant agreements and invoices. We don't have any flexibility on IOLTA and EF side.
Okay, so it just seems to me that we're in like an impossible situation, and I'm fine voting on it. I mean, I'll just have to figure out what we're going to do. I think it will impact the quality of what programs are going to be able to do when you have all of those deliverables due within that 4 or 5 week period of time. And that's just, we're all going to vote and we should just vote. So I think.
Well, let's, whoever thought having all this money was going to be so miserable? Gosh. Anyway, so let's appreciate everybody's comments, and this will be a burden for sure. Let's move on, unless anybody has any further comments on this. We'll come back and vote on it, but let's just look at the whole picture before we vote. So Chris, why don't you move on and talk about the RFP grants?
Yeah, and this timeline is a little more generous by 1 month. So for the competitive or RFP, request for proposals grants, the HP Funds Committee and staff propose that for a January 1 release, the committee would need to approve the RFP and the scoring rubric by August 31st. And so there is a resolution on the next slide that recommends that the commission delegate authority to the committee to approve the request for proposals and scoring rubric. And that would facilitate a September 1 release of the application. This timeline would also give programs a month to apply, so they'd be due back about October 1st. The committee would recommends that it calibrate to the rubric as a full committee, at least 3 to 5 applications. That would be just a few business days later after the applications come in. And then to facilitate a January 1 distribution, and the committee discussed this at great length, and some committee members might want to jump in as to the nuances of their thinking. But the consensus at the end of the meeting was that it made sense for staff to score the applications, having heard the committee's instructions from its calibration exercise. Staff to score the applications and then come back to the committee in late October with staff's recommendations for scores and award recommendations, and to explain to the committee all those scores and justify them in the committee to evaluate those recommendations. The Assembly Bill 164 requires that the commission approve the awards. So that would come up for the commission's approval at its existing November 17 meeting. And then staff would need about the time between November 17th and when the winter holidays begin to facilitate grant agreements and process invoices for payments for January 1. The only commentary I'll provide here is that the amount of time for programs to submit their applications about the same. It's 1 month. Unlike the formula grants, they would actually submit their budgets for the competitive awards as part of their initial application. The formula grants, they can't because the allocation they get depends on how many people are found eligible, but for the competitive, they would submit the budget at the same time. So there's no need for a separate, that buys a little bit more time for the scoring process, but the scoring process, it being a competitive process, will just take a lot longer. Even though the amount of time to submit the application is about the same, 1 month, it will take more time for them to submit a competitive grant application. They can't just copy and paste 90% of the language from the last formula app like they can for this round of formula grants. It's probably going to be like a unique project that they're going to have to think through and describe in a very compelling way. And it will have more questions. The application will have many more questions to ensure that they aren't using the funds to supplant existing resources, and to help the committee and staff come to the correct decisions for scores. When comparing responses to the scoring rubric, it will require more fleshed out narratives.
So Dawn, did you have a comment?
Yeah, I was just going to say the same thing. The RFP application is a lot more intense and rigorous than the formula application. The formula application really boils down to two substantive questions that, to verify that they have qualifying activities. The RFP application is a quite intense application.
So they'll have, if we keep in mind the timeline for the last tranche of this, the formula grants, so they'll have basically an extra 2 weeks to do this one. They'll have till October 1 to do this.
So they'll have the same amount of time to submit their application from when the application becomes available to when it's due. But
right.
They'll have more time to think about
what
they want their project to be before the application goes live. And honestly, that's mostly because the committee would need to meet, if the commission delegates authority to committee to do this, the committee would need to meet to approve the scoring rubric before the application could launch. And the earliest that we think we can squeeze that in is the end of August.
Any other? So I will say that any commissioners who are interested in the rubric and having some input into the rubric who may not be on the committee are invited to come. Wouldn't be voting members, but could come to the August 31 meeting, because that really is the time to provide input on the rubric. We won't be coming back to the commission for approval of specific awards until November. And at that point, it'll be a bit late to start weighing in on the details of the rubric. So if you're interested, come to that committee meeting on August 31. Are there
So
any?
just because I'm sharing my screen, I can't see if anyone raised their hand, but.
I'm not seeing it. Is there a hand raised? I don't see one. Or comment?
No, you're clear, Eric.
Okay. Well, a lot of money and a lot of work coming forward.
So we might want to, oh yeah, go ahead.
Sorry, this is Danielle McCrae. There is a comment in the chat feature that asks if an LSO is applying for both of the grants, will they have to apply for different purposes to avoid the supplants existing funding? Seems like if they are approved for the earlier grant, then the second grant might then be duplicative if it is for the same purpose.
They would have to, yeah, so the competitive grant, if they choose to apply for it, cannot, their response to the non-supplantation question has to address how they won't be using it to fund the same activities for which they're using their formula grant. So that the answer is that they do have to be separate. And that's in the statute, or that's in Assembly Bill 164.
Bob?
Regarding the spontaneous suggestion inviting other commissioners to attend the 31 August meeting, I suggest it may be worth keeping track of who says they want to join in, because what if so many members not on the committee join that it suddenly becomes a quorum of the full commission? And then we have an unnoticed meeting of the full commission.
Well,
that's a great Bagley-Keene question. Good one to ask.
You are Robert's Rules of Order. It's amazing.
No, Bagley-Keene overrides Robert's Rules of Order. But if Bagley-Keene's quiet, then Robert's Rules, and I'm suggesting we might have a quorum of the full commission, not have a notice, instead of get a serial meeting.
I'm sorry, I missed the question.
There was a spontaneous suggestion that commissioners not on the committee that's going to hear this on 31 August, that they consider, if you want to join in to get a better feel, understanding for the details and specifics. I said, watch out that there are not so many members of the commission who join in that suddenly you get enough members participating, monitoring, that it becomes a quorum of the full commission, but lacking public notice that it's a commission meeting as opposed to a committee meeting. You might.
So that's a very good point. And, as long as, and we recommend this in general, to come and watch and, don't even get promoted, just watch, like any member of the public could watch would be fine. It's
right,
when you start talking that a problem occurs.
Keep our mouths shut, so to speak. Okay.
Well, yeah, I mean, I guess I didn't think I was suggesting anything other than what the standard practice. I mean, all of our committee meetings are public meetings. So, I mean, anybody can come to a public meeting and the public can comment, right? So that's.
Well, the commenting then becomes a problem because when you're a commission member, we've had this argument before. It's best not to speak, because you're not speaking as a member of the public. You're speaking and your comments are received as a commissioner. But yeah, watching is fine, or watching after the fact even.
Let's see, Pam, you had a comment?
No, that was my understanding, was that we were just going to be there to listen in. And so just to learn about the process. So that was just my understanding,
Right.
just like a fly on the wall.
And Will?
I'm just confused because this sounds opposite of the past suggestions for myself, that I can come and comment at committee meetings, but obviously not participate as a voting member. So I'm hoping to get clarity.
Yeah, that was my understanding of it as well.
Yeah.
Brady, is
Yeah.
it just a threshold of like number of?
I mean, it's a
commissioners?
threshold of the number. I mean, if you just keep yourself to the public comment period, usually how we've seen it is you start jumping in the conversations because you're not just a member of the public. You're somebody who knows a lot more than most members of the public, and who's you know, as a commission member who's eventually going to be reviewing these decisions, your input is sought more. So again, we've advised to avoid it as much as possible. And again, it's when it becomes half of the commission. So if just one of you is talking and the rest of you are silent, it's probably not technically a violation. But again, we're trying to follow best practices and avoid creating a violation. But I think we're probably getting ahead of ourselves since this is a few weeks off.
Yeah, I think we are as well. Let's go back, unless there are further comments on that or questions about the RFP timeline. I think we had the resolutions that were coming at one point.
So I you know, the committee's memo to the commission presents the resolutions in this fashion. It's like this would facilitate a single vote because the bullet points 2, 3, and 4 are further resolved. But if the commission wanted to separate these out, I can put them on different slides. But as presented in the memo, this is how they look. And I think it might be helpful for me to read them out loud, just so people can like listen and think about them as I say it. So if the committee were to vote, or the commission were to vote on all of this at once, it would be resolved that the Legal Services Trust Fund Commission approves the December 1, 2021 timeline for the 2021 homelessness prevention formula grants, and the year that precedes the name of the grant is the year that it would be released, and January 1, 2022 timeline for the 2022 HP competitive grants, as presented in the HP Funds Committee's August 13, 2021 memo. It is further resolved that the commission delegates authority to staff to review and the committee to approve eligibility and allocations for the 2021 HP formula grants. It is further resolved that the commission delegates authority to staff to approve budgets for the 2021 HP formula grants. And it is further resolved that the commission delegates authority to the committee to approve the request for proposals, including scoring rubric for the 2022 HP competitive grants, and to staff to score applications in consultation with the committee. And so these were the delegations of authority that were implicated in those timelines. And I'll just leave that up for a while and can take a moment to read it and ask about it.
Yeah, I would propose to take these up separately in light of, I think, Bob's comment.
I'm going to exit full screen view so I can pull up some blank slides and we can, so just 1 second.
Do people have questions about those resolutions before we entertain motions?
I think we can just vote on this whole, right? There's no procedural.
I see a comment or question from Zahira. Go ahead.
Thank you. Thank you. You know, it's less of a question about the resolutions and more of a comment just about the effort to get like large sums of money out. And, you know, I would just say that getting large sums of money out in a way that is going to be effective and productive is quite challenging. And there are lots of different pots that we're kind of giving out. I think that the comments from Selena were really helpful and informative in terms of what impact this would have on the legal services community in terms of getting the funding out. And so, you know, this is a lot of money and a lot of different timelines to try to release. But if there's confidence that, you know, the community is ready to receive all of this at one time and has the capacity to kind of work through to ensure that we get some quality kind of proposals back, you know, then you know, these suggestions I think make sense. I would like to just, I guess, add in some cases where, if it's possible, with some of the funding, if there's an urgency in terms of the expenditure of some of the resources, if there is the possibility, in some cases, kind of getting back to the question that I was asking before, to allow for some level of use of the funding, be that at the beginning of December, depending on when the release comes out. I think that might also be helpful for organizations, especially as they're trying to address some of the changes in law that will be happening at the end of the year and going into next year. But this is a really big task. And I just want to thank staff for coming up with these different timelines, and for Selena and others for doing some preliminary review and research to see whether or not this was feasible.
Yeah, thank you for that comment. And I agree. There's a huge burden here on staff and on the community. Juan, would it be possible if we approve these resolutions to just in parallel check on Zahira's question just to see if there is any flexibility?
Yeah, I think I would need to confer with Brady, because it's the grant agreement, and I'm worried that if you release a grant agreement but the expenditures backwards, I think I need a little bit more time to research that. I couldn't provide an answer on the spot. I mean, we want to be thorough, make sure that it's in alignment with, it's okay with our grant agreement. But if you all will give us that flexibility, we can do that, and give staff the authority to then allow us to, if we were able to allow programs to get expenditures beyond the backwards in time, I guess, is what Zahira is asking, then we will do that.
Do we actually have to give you authority for that, or can't we?
Well, it's not formal, but if you let us know, we don't have to take a vote on it, but we will.
Yeah.
Yeah.
I mean, I suggest you just check it out, and if we have the flexibility, we can inform programs that they have that flexibility, I guess.
Sure. And was there your other question, whether we could vote all four of these together? Because my suggestion would be to vote together the way that the memo is presented, unless you feel strongly that they should be separated.
Anybody have a strong view? I mean, I'm happy to consider them together.
I'll make a motion to approve all four resolutions together.
Second.
I'll second that. Oh, Bob second.
I'll do roll call. Aglagi,
Yes.
Iskin,
Yes.
Al-Saraf,
Yes.
Ball,
Yes.
Artelson, Fightmaster,
Yes.
Bennett,
Yes.
Blakemore,
Abstain.
Boschelli,
Yes.
Connolly,
Yes.
DeBose,
Abstain.
abstain, sorry. Herman, was that abstain or a yes? I'm sorry, I missed that.
I was abstain.
Okay. Rebecca Delfino. Friedman,
Yes.
Zahira Mann,
Yes.
Meeker,
Yes.
Plantold,
Yes.
Ryanus, Savage, Schreiber,
Yes.
Vanarelli.
Yes.
Motion passes.
Thanks, Tuan. Thanks, everybody, for a great discussion.
We actually have one more motion that was
Which we
included in
think is a
the-
little, yeah, which I think is probably not too controversial, but it did arise as a result of information that staff received after the memo was submitted. Duan, do you want to actually provide any context for this one?
Yeah, so this wasn't included in your memo, as Chris said, because we just got direction and confirmation from the Department of Finance that we can release multi-year grants. So the memo and all the PowerPoint was drafted in a one-year grant period, but we would like the commission to approve that we can administer the HP grants in a 3-year grant cycle with the $80 million combined funding. So then we'll go back and adjust the numbers in terms of, it'll be a 3-year grant instead of a 1-year grant. And Chris's slides, all the numbers all reflect a 1 year, but we would adjust it, the $80 million across 3 years. And providing programs with a 3-year grant versus a 1-year grant will give them the stability in order to plan and hire.
Okay, but we're only distributing 40 million now, right?
We are our contract with the Judicial Council we were only in receipt of 40 million. Yeah.
So, okay, so what we will approve for the formula grant and the competitive awards will be the first 40 million, and that can be spent over 3 years. Is that the idea?
No, the idea is that they would be able to do a 3-year budget for $80 million.
And they do deliverables for all 3 years then in this same truncated period of time?
Yeah, that's usually how we do with our multi-year grants. We've dealt with it. Our bank grants were 3-year grants. The last HP grants were also 3-year grants.
So they'll submit budgets based upon the expectation of 80 million?
Yes.
And program deliverables based on an expectation of 80 million,
That's correct.
all of that. So it's essentially a one-time grant application for 3 years. But you have to account for a fair amount more money. I mean, it's really not, it's 80 million for the formula and for the competitive awards, right?
Yes.
So it's really broken into 2 different pieces, but both of them would be over 3 years.
Yes.
So Jim, did you have a comment?
Yeah, question on that. I mean, the recall may very well impact that second 40 million, might it?
You know, I personally didn't contemplate the recall when we drafted this. I can't speak to that. I think Donna already signed off, but
if they don't, okay, but if the other 40 million or any part of the other piece doesn't come in, for whatever reason, if it's truncated, then I guess what happens?
Then you would have to revise your application, I think, to reflect a fewer number of deliverables and a budget that reflected what the actual money was. I mean, that's the only way it seems like it could work.
yeah, it's awkward because the state budget is only a year, and that's why we've been trying for the last few weeks to get more clarification from DOF, and they have given us clarification that they would be comfortable with us.
Yeah, I just feel like it's what Donna said. We can't really think about what the recall is because the recall is only for 2 years or less than 2 years. So by the time you got to the last year, you could, who knows? I mean, it's just trying to predict for those seem impossible. And so it's just knowing that life changes and there might have to be an adjustment back down if we want to proceed with paying to programs initially contemplated for this larger amount.
Shouldn't we have some sort of language that puts people on alert that the second 40 million is not guaranteed?
There is language in our grant agreement. If we're not in receipt of the funding, then
okay.
Is there any language that we can add that would protect the grantees from having to give back money if somehow the money doesn't come through and there's some effort to take it back?
Well, it's and how it works is we would release the funding that we have, so the $40 million would go, and we need to think about, I guess, if we're dividing it by 3 years. That's the piece that I need to check with Donna to see if the legislature was okay with splitting the 80 million equally across 3 years, or if they wanted us to distribute 40, 20, 20. But that aside, we could release all the $40 million once we're in receipt of it. We do with our discretionary grants, an annual check. With IOLTA and EF, we do quarterly checks. So they would have to give it back because we would have the funding in hand and we would distribute to them.
Well,
the 40 million.
Would they not be able to encumber the full amount that was granted, even if it's not released?
Well, that's where our there's a provision in our grant agreements that protects us in the event that we don't get the additional 40 million. But I guess I don't think I'm understanding your question.
Oh, I'm just wondering what would prevent the grantee from encumbering more than is released if they say, hey, we got a grant for, the full amount that they received or that they were promised to receive under the grant for the 3 years. So should they be warned that until the money is actually released to them, they shouldn't encumber it?
Yeah, so I think that's where I'm saying, I think our grant provisions protect them, but we can make it more clear than that because it's a little bit of a unique situation in that we don't, not in receipt of the other $4 million yet.
Yeah, Brady, did you have a thought about that?
But I mean, our grants, our contracts in several places say, none of this, all of this is depending on us actually getting the money. You're not guaranteed any amount until you get it. So it's understood.
So Will had a comment.
I just wanted to add that you can't see me, but I'm jumping up and down. I think this is an excellent opportunity for programs to get creative and use that flexibility to fund programs. So thank you to staff and whoever else had a hand in making it happen. Thank you.
Erica?
Yeah, sorry, this may be kind of a silly question. Would the organizations have to do this 3-year planning?
Like if they could they use like their portion all in 1 year?
Yeah, I'm just trying to get a sense if this is like, because I think we, in the eligibility and budget review, we allowed for 2 years, but they could also do 1. And I'm trying to figure out if this is the same flexibility or if it's mandated.
I don't, it wouldn't be the same flexibility just because of the other 20 and 20 had, you know, our contract with Judicial Council, we're not going to be in receipt of it. The Judicial Council doesn't get the other 40 million either until the following year. So.
But wouldn't Dwan, the flexibility be if you're a large program and you're going to get $3 million and because you're also getting 50 million, $5 million other dollar increase, you could then decide you're not going to spend all of your money in this first year. If you got 3 million and you only thought you could spend 1.5, you could put the other 1.5 over the next 2 years.
Oh, I see the other direction.
So you could go the other direction. You can't account for money that you don't have.
Right.
Yet, but I think you ought to be able to have the flexibility with, if you have more money than you think you're going to be able to effectively spend and hire staff for, spread it out over 3 years, which I think is, from my perspective, the advantage of that.
Sure, and I think that would be the committee could, when the HP committee reviews application, I think that's a strong case. We have typically in our office, and doing an uneven number is really hard for us to keep track for various reasons. Usually when it's 3 years, we like to split it up equally amongst the 3 years for our tracking purposes. And then if they have a budget revision, they request at the end of the year. But again, we're still getting direction from DOF, whether we can smooth this out, 80 divided by 3. That's a pending question right now, or whether they want us to release the full 40 and then 2020 for year 2, year 3.
I guess what I'm saying is like, my question maybe is a little bit different, which is like, are they applying for like funds for 3 years?
Yes.
Or like they can't just apply for like funds for the 1 year that's guaranteed?
Not if they're gonna take not if they're gonna take their share of the 80 million. I guess like you do raise an interesting question. If they only wanted to take their share of the 40 million, would we allow only a 1-year grant? I guess I don't see why not.
But then they would lose the opportunity to get the other 40 million, right? They would have to make that.
So they have to make the decision now if they're going to go 3 or 1. Well,
Yes.
we're not even giving them really 1. Okay.
Yeah, and
maybe this is all hypothetical and everyone wants all the money for 3 years. I was just trying to get a sense of
and we haven't built it out like that. So you do raise an interesting question because we're pre-building out everything because it's such a tight timeline, and it's not right now currently how it's built out doesn't contemplate that option of 1 year. But I'm thinking right now, could we do it mechanically and our tracking? This is all very complicated for us to track, and we want to keep good records and everything is reconciled. So that's the other consideration for us.
So Joan, I guess the only flexibility I hope I would encourage, you all should do this however it's going to work, but knowing that you're going to get twice as much money in the first year, it seems to me that the flexibility to however it works for the program and the bar to spread that out so you might have more equal amounts over each of the 3 years would be helpful.
Yeah, I think that's our preference, if we can divide the 80 by 3 versus doing 40, 20, 20. And that's the pending question from the legislature that we haven't got response from. And, I could check with Donna and both Selena, because they've had the communication.
I was just going to say, in response to Erica's comment, there have been instances where programs have given the money back because they haven't spent it or weren't able to spend it in out years. And so I do think that seems to be like a likely outcome. Programs will apply for multiple years, realize they can't execute for whatever reason, and then return the money. So that has happened.
So I have a question, Dwan. I had assumed when I first heard about the 40-20-20 that we were going to actually go through 3 different rounds of formula grant applications and RFP funding for each of 3 years. But what I'm hearing you say now, I think, is we're just going to have one. We're going to have one application for a formula grant for 3 years and one application for RFP funding, and that's it.
Yeah, that's what we're contemplating, just so that programs have that assurance that they would have 3-year funding. Otherwise, they don't have assurance to hire.
Okay. Well, any other discussion on this resolution? Is there a motion?
Catherine moves.
I'll second. We'll let Will second, since he's jumping up and down. We'll let him second it.
Thank you, Eric.
All right, I'll do roll call. Aglagi,
Yes.
Iskin,
Yes.
Al-Saraf,
Yes.
Ball,
Yes.
Artleston, Fightmaster,
Yes.
Bennett,
Yes.
Blakemore,
Yes.
O'Shelley,
Yes.
Connolly,
Yes.
DeBose,
Yes.
Delfino, Friedman,
Yes.
Mann,
Yes.
Meeker,
Yes.
Plantold,
Yes.
Rhinus, Savage, Schreiber,
Yes.
Vanarelli,
Yes.
motion passes.
Right. Well, so should we keep powering through here? I guess we're almost done.
We're almost done.
All right. I hear Christina shaking her head yes, so that means we'll go ahead. All right. So, Dwan, why don't you give us the IOLTA revenue update?
Okay, this will be quick. Hold on. Sorry. And it's good news. So we got May remittances and June remittances, and they're much better than what we thought when we went to do projections a few months ago. So our May remittances about $1.9 million, and June remittances was about $2 million. And what we had projected, if you all recall, was a moderate projection of about $1 million per month. So we're about ahead of our projections by about 1.7 million. So really great. We're conservatively optimistic, but this is, so far so good. And every time we meet, we can provide another update.
So does any increase in terms of funding just add to our reserve at the end of the year? In other words, we're not going to distribute anymore.
Oh, no. The distribution we have to go run the formula. Literally, everybody's geared up to test and run the formula on Monday, so we can't make any modifications to the distribution next year. But this will, whatever increase we have, it just goes straight to our reserves.
Great, good. That's good news. Any questions about that? Okay, expungement, our favorite subject. Let's move on to that one. So who's gonna do that?
Brady is actually going to take the lead on behalf of the working group to present on this. Kim, can you promote Brady? He said he's as an attendee. Brady, are you on? I don't see you. Oh, you're on, but you're on mute. Okay, great.
Yes. Get this lighting. Having connectivity issues. So, just to provide some background, and we've spoken with various constituencies and groups of you about it. So, last we spoke about this as a large group. I believe we discussed the staff proposal that we basically treat as permissible as qualified expenditures and for primary purposes determinations grantees expenditures on expungement and record clearance type activities, as well as grantees infractions activities, because the statutory language basically required us to treat those as qualified expenditures and as counting towards primary purpose, despite the fact that the statute, again, by limiting the expenditure of our funds, or by barring the expenditure of our funds on legal services related to criminal proceedings, wouldn't let our grantees spend the money in that way. So it was sort of a split decision necessitated by the statute. You can count those monies in terms of your eligibility and your allocation, but you can't spend our money on them. This issue had come up last year, and at that time we raised with the legal services community whether they wanted to pursue a statutory change to sort of address expungement and infractions work, which arguably should be funded since it's not covered by public defenders. And at that time, there wasn't an interest, but it turned out that this summer, in a very tight time frame, there was some room and willingness to approach the legislature, and staff of the relevant committees at the legislature indicated a willingness to change the statute if the state bar and the legal services community represented by LAC could come to agreement. And so our working group made up of Justice Murray, Judge Seligman, Catherine Blakemore has been meeting with each other and with Selena, the LAC representative, to work on some language. And I will pull that up now, which addresses these concerns. Does everybody see that? So essentially, this makes some edits to the IOLTA statute to clarify. First of all, there were some probably unintended absence of the word civil from various parts of the statute, and that we discussed last June, which is that it defined both the primary purpose determination and qualified expenditures with respect to legal services for the indigent, not civil legal services for the indigent. Was probably unintended, and the issue there, the result of that was our determination that yes, we could let grantees treat expungement and infraction work as qualified expenditures for primary purpose and the allocations purpose. But a corollary to that is that the statute technically would allow applicants to count purely criminal work as qualified expenditures and their primary purpose as qualifying for primary purpose, which we did not think was intended. It was not consistent with past practice. So these amendments would make clear that it is civil legal services for the indigent that count towards primary purpose, qualified expenditures, and on which grantees must spend our funds. And then we added some language, both at 6213L, I believe. Let's see if that's 6213L, defining civil legal services, or not entirely defining them, but saying that in civil legal services do include legal services related to expungements, record sealing, or clearance proceedings, not requiring a finding of factual innocence. So in addition to expungements, certain other record sealing and clearance, record clearance proceedings that don't actually challenge the underlying criminal conviction, don't revisit them, but are more civil in nature, as well as infractions. And infractions, again, are things like traffic tickets, minor violations that would not be punishable by jail time, and therefore people would not be entitled to representation by the public defender, at least not constitutionally. And Same changes repeated throughout where necessary. And then in 6223, section 6223 of the Business and Professions Code, where the prohibition on spending our money on legal services, legal assistance with respect to any criminal proceedings occurs, we added the language of this article: criminal proceeding does not include expungements, record sealing, or clearance proceedings not requiring a finding of factual innocence, or proceedings concerning infractions. This language, we believe, is broadly acceptable to the legal aid community, in that it funds the work that they seek to fund, which again is not traditionally criminal, but under the existing statutory language would be considered criminal, while also meeting some of the concerns of the working group that we're not funding work that is traditionally criminal and to which the indigent would already have a constitutional right to counsel. So I don't know, Dwan, if you've sent this final language to Selena yet, but this, from our perspective at least, definitely addresses their concerns, and we expect to have agreement such that the legislature will hopefully be able to move on this.
Yeah, I have not sent it to Selena because of the back-to-back meetings, but we do plan to share it with Selena so that she can get feedback to the community. But we are in a very tight timeline to have something that everybody's is agreeable to everybody, so that the legislature can get this passed.
This is Judge Jaskell. I have a question, and I don't seem to have the little hand raising function. Since I can't see the whole statutory proposal, so it looks great in the sense that it's defining civil legal assistance to include expungement. Does it include other definitions of civil legal assistance, such as, family law and other sorts of things that would fall under civil legal?
No, and we didn't. I don't know that the choice was made, but we did not endeavor on a quest of coming up with an all-encompassing definition of civil. Rather, we just wanted to make clear that in addition to what traditionally has been considered civil, and there's never really been a question about, we're making clear that these things will be encompassed in that definition.
Well, that does concern me just a little bit. There's, for example, I think canons of statutory construction that might give us, I think people would understand what you just said, and that of course we're not excluding things like family law, obviously, but by defining one kind of thing as civil, I'm just wondering if it might be safer to include a broader list, and you could say civil includes not with language saying not exclusive, but here's some things that fall within civil. This list is not exclusive. There's guardianship. There's a wide range of things that fall within civil, and I would hate for there to be any ambiguity.
Judge Seligman?
Yeah, in addressing that issue, Judge Gaskell, we talked about a bunch of things, but our main concern here was we're under an extraordinarily limited time frame. In fact, we need to get this language to the legislature by Monday. And we were concerned about unintended consequences. Our whole discussion focusing on criminal was a discussion to make sure we weren't going someplace that was going to open up a broader, more confusing area. And this statute has not defined civil for, I think, decades. And maybe we should do it, but I don't think we can do it intelligently by Monday. The other thing I wanted to say is this language that we are proposing is consistent with what the Federal Legal Services Corporation has permitted for the last 20 years, at least since 2002, as I understand it. So we're not going here into some remote area. It's something that there's a lot of background and history on. So I think that what we did was pretty comfortable. My understanding from the communications with Selena, although she hasn't seen this exact languages, but I think she's pointed out the federal LSC language as something that they're comfortable with.
So Judge Marie and then Christina.
So I don't think that that definition of civil necessarily excludes everything everybody understands as being civil. I guess the idea would be to say something like including but not limited to, but what I think we were trying to do was to make it really clear that there's this sort of small list of things that might otherwise be considered criminal that is also included within the definition of civil legal services. That, of course, encompasses everything that everybody's come to understand as being civil. The CFR section that encompasses the Legal Services Corporation definition of criminal proceeding reads as follows. Criminal proceeding means the adversary judicial process prosecuted by a public officer and initiated by a formal complaint, information, or indictment charging a person with an offense denominated criminal by applicable law and punishable by death, imprisonment, or a jail sentence. So as Judge Seligman said, we think this definition, I would say, is generally consistent with the LSC definition of criminal in the sense that infractions are not typically an adversary process prosecuted by a public officer. Now, I think there probably are some small group of infractions. For example, when I was in the DA's office back in the day, I supervised our environmental unit, and we had a really active oversight over the Delta. And so we did charge a bunch of fish and game infractions, and we did stand up in court on those. And I think some other counties followed suit on that. I don't know what's going on now, but that would be an example. But I think it typically, there's no adversary process. There's no prosecutor. They're typically not initiated by a formal charging document. They're not punishable by jail, but the fees, the fines, the penalty assessments can be financially crushing. And so, although in California infractions are denominated as criminal, I think the other factors that are within the CFR that I said that I think are kind of consistent with the CFR give us, some comfort in the sense that we're sort of drawing between the lines of keeping within the lines of the CFR definition and our definition in California. We did not want to be general in nature because then we might inadvertently bring in some other criminal proceedings that we think are really criminal proceedings. For example, criminal proceedings that might relate to misdemeanors and felonies involving a determination of guilt or innocence, or a determination that somebody is innocent, or they might be otherwise criminal in nature. So that was what we were seeking to do, was to accommodate the requests of the legal services community to let them be funded for some of the work that they've been doing out there as it relates to infractions and record sealing and record clearance work and infraction work, which all of those things sort of serve as barriers to employment, to housing, to consumer debt relief, to other civil relief or other matters that the legal service community might be providing to these clients. So That was the goal. Nobody, as far as I know, from the legal services community has said, hey, wait a minute, you just excluded everything else that was civil by that definition. That hasn't been the reaction. So, and I don't think anybody would ever read it that way.
All right.
Christina?
Well, I was just, maybe I'm overly simplistic, but isn't everything that's not criminal civil?
Yeah, so that I think that's right, but technically, and that's why I said technically expungements are criminal.
Right, that's why we're bringing them in.
Right, technically.
Okay, so I don't see an issue.
Oh, I'm sorry.
Yeah.
Yeah.
No, I was like, isn't that the general, isn't that right? Everything is civil that's not criminal, and we're going to bring in a couple of things that technically are criminal, and we're going to call them civil for our purposes.
They're included within the definition of civil legal services for purposes of this statute. Yes.
So I don't think we need to give a list of what is civil.
I really don't either, and I don't think anybody would read it that way. So.
Okay.
That was our thinking.
So, yeah, thank you. I totally agree. I mean, I sit in traffic court as a volunteer temporary judge, and I completely agree that the fine paradigm structure is really oppressive. So it's quite helpful that organizations can be involved in assisting people to deal with those. I did wonder, though, when I read the comments of Neighborhood Legal Services, there was a reference to motions to dismiss and demurs. Does anybody know, are there a lot of motions to dismiss and demur?
I had no clue that was happening, but I've been so far removed from traffic court for 20 something years now. So I don't know what they're doing. You know, I do know they're doing a lot of work representing people in the homeless courts, the veterans courts, those kinds of problem solving courts, where, you know, they have clients who pick up a number of different kinds of cases. They could have a bundle of cases that could be felony, misdemeanor, and infractions. And I don't know, maybe they are doing that kind of work, trying to beat the infractions by filing demurs, or what. I don't know. I have no idea what that would look like. I've never seen it before, but I did read that.
So I'm sorry, it's Catherine. I'm gonna have to leave to get on another phone call. So my only question was, do we need, so we have this language that's parallel. We put it in civil, and then we also say it's not criminal down below. Do we actually need to define this as civil as opposed to just saying it's not criminal? And does that solve the problem differently? No.
No, well, because unless we, you know, rewrite the entire structure of the statute, the primary purpose and the qualified expenditures for allocation purposes are defined with respect to civil. And separately in 6223,
then you have to exclude civil.
Spending our money on criminal.
Okay, that's helpful. Thank you. And I want to just thank the people that worked really hard on doing this in a short time frame. And I think it's absolutely the right thing to do. And I support going forward with it. And if problems arise, I'm sure we'll have the capacity to fix them. So since I have to leave, I just wanted to thank people that worked hard and thought hard about this, and to Brady for all the work he did with drafting along with other staff.
Yeah. Thank you for that comment, and thanks to the group. Any further discussion? We don't need a resolution on this, do we? This is just a discussion item.
No, this is just an update for the commission. Yeah.
Okay. So what are the next steps that we're gonna recommend this to the legislature? Is that
well, the next step is we're going to share this with Selena, who's going to float it with the community to make sure that they're comfortable with this language. We don't really anticipate this is responsive to their request, and then we will share it with the legislature. And the legislature has expressed that so long as the commission and the community is in agreement, then we should be able to get this passed
this year.
Mm-hmm.
Okay.
It will be included. There was a question whether it would be included in SB 211 or 498, and we think it's going to go in 498 with the increasing the income threshold from 125 to 200%. But that's still getting ironed out.
Okay, unless there are any further comments, let's move on to liaison reports. Is Selena still on?
I don't see her. Perhaps we could do Bonnie first, then I can text Selena.
Okay. So Bonnie, you're on for the Legal Aid Association of California report.
Oh, Bonnie says she needs to be unmuted. Kim, can you promote Bonnie and unmute her? And Selena's also on too. She said that she's as an attendee. Can you promote both of them, Kim?
Well, if Selena's on, why don't we give her the time now? We're waiting for her to be promoted.
Yeah, I think it's Kim. I'm not sure if it's a number that doesn't have a name attached. The 510.
She's on her phone, so it won't let me promote her. It'll just
I think I'm
let her
here.
talk.
Okay, great.
Can y'all hear me okay?
Yes.
Oh, fantastic. Yeah, sorry. I was initially promoted, but since I'm on my phone, I think I accidentally unpromoted myself or signed off, so I apologize. So I will make my report fairly brief, but because I was muted for a couple of things, I just wanted to quickly loop back on a couple of open issues. So one of them, in terms of our work with the state bar, I can say that the budget work is really separate from kind of typical legislation that, you know, moved forward by the legislature and signed by the governor. What's especially helpful here, as Dwan said about the increase in the homelessness prevention dollars, is that we did get confirmation from the Department of Finance that the next 2 years are in there. You know, it's 40 million, it's definitely in for this year. It's a budget act, it's already, you know, out the door. And the next 2 years are part of the multi-year budget. It just won't be given to Judicial Council until future years. And I do also want to add that LAC continues to advocate to increase this funding. You know, we had originally asked for, oh goodness, I think probably something like 200 million over 3 years. But this is federal funding that we don't think it's all been allocated. It's CARES, you know, it's coronavirus related funds. And if it's not all allocated, we're continuing to advocate for this kind of supportive funding to be able to be spent in support of the legal needs of low-income Californians. So I hope that we have an update next year that we're able to carve out additional funds, but I feel like these funds are really kind of separate and a little bit more protected than kind of general legislation. The next thing I want to say is I'm in strong support, and I'm so grateful that the commission voted for 3-year grants for homelessness prevention. I think what's especially important here, because of the no supplantation, we will, you know, organizations will really need to hire, and having a 3-year grant will allow them to hire new staff. So I think that's just, you know, just, I'm really grateful that you voted to, you know, talk about it as a 3-year grant. I also, with the IOLTA reserves increasing this year, I think that's a fantastic time because organizations have said, as many of you have noted, there's a lot of funding this year that's going to be an increase, but IOLTA is the most flexible source of funding for programs where they can really respond to different community needs. It's not as restricted for homelessness prevention or for, you know, other, you know, partnership grants. And so having these funds available for future years, I think will really help, as organizations may have to see a decrease in their equal access fund, or you know, their HP2 will end in a couple of years too. So I just think that was a really, you know, serendipitous change. I think another update, this feels very much in the liaison space. We're working with the California Commission on Access to Justice and with the State Bar and many others on issues around loan forgiveness. One thing that we're doing for our community is in a couple of weeks, we're doing a training for legal aid advocates and attorneys, understanding their own student loans. I think many of you are aware that the Federal Public Service Loan Forgiveness Program had a number of issues in rolling out and forgiveness. So we've actually hired a loan expert who's going to do a training for our community, so people understand how they get the right paperwork in, that they get the right timing in. Because I think that we've seen in the State Bar and LAC's you know, recruitment retention work is that crushing student debt really does impact attorneys' ability to enter legal aid and to stay in legal aid. And I'm almost done with my bullet points here. Another one, I wanted to echo Catherine Blakemore's comments around all of the work that went into new language around including expungement, record clearance, and infraction work. I know that Justice Murray and Justice Seligman and Catherine met many times with Brady and with Dwan. And I just want to thank not only the working group members, but also all of the State Bar staff, particularly Brady, who has been so involved in this issue of looking at the statute and just as Murray said something earlier about, problem-solving courts, this felt like a problem-solving group as well, of figuring out how organizations are incorporating this work as part of their anti-poverty mission, and also how they're helping to solve problems. It's not just the eviction that comes in the door, it's also all of the other legal issues which could be infraction related. It's a barrier to housing, a barrier to employment. So I want to acknowledge that was a lot of work, and thank you for that work. And I think that was it. The only other thing I just wanted to mention just real quickly is that we're working with Judicial Council and the State Bar staff on a lot of convenings over the next 6 to 12 months. With all of this new funding from programs, we want to make sure that they are reporting the data that is helpful, especially as State Bar is reporting with Judicial Council on these federal funds. We want to make sure that organizations are asking all the right questions, that they're getting the technical assistance that they need, because a lot of these funding sources, we actually could either extend them or we could use them as a way to kind of prove that other funds are helpful in order to help our community. So we have a lot of convenings coming up, and to the extent that any of them are open to members of the commission, I'll make sure that we send along an invite. And I think that's it for me.
Great, thank you, Selena. And thanks for your contributions today. They're very helpful. Okay, Bonnie.
Bonnie, you're on mute. We see you, but you're on mute, or we can't hear you.
You're still on mute.
It doesn't say you're on mute, the volume.
She's not on mute. We just can't hear her.
Yeah.
Is she technology impaired?
Bonnie, you may want to also call in. Maybe that might work.
Okay, how is that?
Brilliant. Yes.
Okay, all right. So you're hearing me through my phone and hopefully maybe seeing me on Zoom. Anyway, thank you so much. And it's, yeah, my internet has been awful all day. But mostly I just want to note that with the federal funding, there are many more reporting requirements that we have been working through with the Department of Finance for the Coronavirus COVID Recovery Act. And so really appreciate the thoughtfulness and the fact that we already had measures in place. And the legislature also added an annual report on main benefits and what was accomplished with the Equal Access Fund. And we have to provide that to the Department of Finance. We've never had that requirement before. So and again, thankfully, we were able to let DOF know that the State Bar has been, and the Trust Fund Commission has been collecting data. And so, but again, there's a real difference between collecting it and having to get it in place in a way that is going to work for our governmental colleagues. So just that's, I just really want to also acknowledge the work of staff in helping to think those things through. There may be some things that come up as we're learning more about the federal funding. Everybody is, trying to sort it out at this stage because of course it's happening fast, but I do think it's, it does certainly seem very secure at this point. The other thing that I think just a point that the Trust Fund Commission probably should know, and I don't think was discussed, is that there was also $5 million that was set aside, again, coming to the Judicial Council, that will be going out to the California Access to Justice Commission for grants that will go not only to IOLTA eligible organizations, but to other legal services organizations for infrastructure and innovation. And they're in the process of setting up those that grant process. And I think that also may be helpful for some of the organizations that might be IOLTA eligible with a little bit of assistance, a little bit of guidance or additional funding. So I think that will be an interesting development moving forward. And it also provides another opportunity for our grantees to to get additional funding for those kinds of projects. So lots going on, and yeah, I think everybody is just incredibly busy. And then I guess the only other thing in terms of Judicial Council, we're working closely with the ERAP, the Emergency Rental Assistance Programs, to try to get the word out through the court system about the availability of ERAP funds to help prevent evictions and help avoid what we're worried about in terms of an eviction tsunami. So that work continues, as does, you know, general work on forms, and we are updating the self-help, doing a whole new version of the self-help website to deal with some of these critical housing issues and the financial lawsuits that may also follow as a result of the pandemic. So that's my report. Happy to answer any questions. But again, many, many thanks to all of you for all your really hard work on these. It's a wonderful opportunity to give out funding, and it's been fun to sort of think through, make sure everything will fall into place. But your staff is extraordinary and working extremely hard on making this happen.
Thanks, Bonnie. Any questions for her? Yeah, and I would echo the comments she made about how wonderful staff is. We make this comment a lot, but it's well-deserved. You guys are working so hard and cranking out even more. So I don't know how you do it. Well, Bonafshe, I guess about our time is just about up here. The sand is going through the hourglass. We're about to fade into history.
Yeah. Well, I wanted to actually echo what you and Bonnie were just saying. I think one of the joys, and I think also the honor of being in the seat of chair, is to have firsthand into what the staff do day in and day out. We work really closely with them, and we really get a sense, some of a sense to some point, of what they're up to and how much is before them. So I want to applaud the staff, and of course everyone for the work that they've been doing, especially on this expungement. So yes, this is it. So I think we got to kick it over to Bob and for
you're
his
on, Bob. Your motion.
Sorry, sure. Let's move to adjourn, please. Move to adjourn. All right. Thank you.
Thank
Stay
you,
safe.
everybody.
Thank you so much.
Bye-bye.
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 See you next time.
Thank you. Have a nice weekend. Bye.
You all too.
See you, everybody. Thank you, staff.